My lord, it is the lordship. Lordship, item number of 37 and 45, my lord. This has wrongly been listed under orders column. These are the admission items, my lord. So my prayer is that after the admission, my lord, these matters may be taken up, my lord.
Item number?
Item number 37 and 45, my lord. Earlier, these matters were listed under admission column, but my lord, this time probably wrongly it has been listed.
Okay. It has to come under
Admission, my lord.
admission.
So, my lord, after the admission matter, these matters may kindly be taken up. Deep to
May please your lordship, the item number 54, lordship, at 2 p.m. lordship. IA for bill earlier the leftover lordship.
Item number?
54. Supplementary list.
No, it will be called serially.
Lordship, the earlier 3 times lordship leftover. Or 3 p.m. lordship.
Okay.
Diplo. My lord, same prayer in respect of item number 53, my lord. The appellant is convicted for 2.5 years, my lord, and he is in custody.
It will be called as per serial.
My lord, then before
Otherwise, we will disturb entire cause list if we change the.
then kindly fix it before rising, my lord.
No, it is admission matter. It will come. It is admission matter.
Before rising, my lord. And the last item before rising.
I'll rise at 4:30. If it reaches,
Okay.
it is your luck.
Yeah, please, your lordship. Lordship, item number 15. I beg to mention that it might be taken some other days.
Item number 15.
Yes, lordship.
15.
Yes, lordship.
Third miss. What's her name?
A. Lodha.
A.
Lodha, L-O-D-H.
A. Lodha, learned counsel for the
R.M. Das, petitioners.
petitioner. You have informed the other side.
Yes, Lord.
9.
Learned counsel for the petitioner who prays for an adjournment. She also submits that she has informed the learned counsel for the respondent and obtained the consent. Considering
On behalf, your name is not here. Your name not here in the call.
he is submitting on behalf
On
of
behalf of.
on whose behalf your
R.M. Das.
R.M. Lodha submitting on behalf of Mr. R.M. Das.
Lordship, there is an interim order as well. Let that be taken.
Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
Okay.
The interim order shall continue till next day.
Oblige your lordship.
May please, your lordship, I beg to mention item number 40 may be taken at 2 p.m. My lordship. So many,
40. All of them
so
at
many
40
times
minor.
listed, but I is not considered, my lordship.
So, but at 2 p.m. we can take only one.
Oh, 1 minor. 4 cases already.
Already there are
Earlier
Two
2 cases
cases.
minor. Earlier 2 cases.
After there are 2 cases. At 2, my lordship, I is not considered so many times listed.
there will be many such matters.
40 item now, orders. Oblige, my lordship.
After this, the matter which was mentioned earlier.
Yes, my lordship. Oblige, my lordship.
May please your lordships. For listing, my lord, one criminal petition, my lord, orders matters, my lord.
No,
if
you
possible,
have to
on
mention
second of
Senior,
there are senior courts taking up this roster.
mention
So you have to mention before the senior most court.
14.
May please lordship. Lordship, item number 51. Lordship, I want to withdraw this matter, lordship.
51.
Yes.
What is your name?
B. Deuri, lordship.
B. Deuri.
Yes.
Heard Mr. B. Deuri, learned counsel for the petitioner. Why are you withdrawing?
Actually, lordship will prefer under provision.
Okay. Who prays for allowing the petition?
Lordship, liberty may be.
petitioner to withdraw the sent criminal petition with liberty to file afresh, considering the submission made by the counsel, the prayer is allowed. This criminal petition is dismissed on withdrawal with liberty to file afresh, if so required. Stop.
Public.
Item number 1.
May it please your lordship. This is a 482 application for quashing of complaint case.
Yes.
For quashing of complaint case, which was filed in Dhubri against the petitioner. My lord, what happened, my lord?
Washing of complaint.
The case of the petitioner is this, my lord. He has taken a loan from opposite party number 2 to the tune of 1 crore 12 lakhs. And and he repaid the amount. But what happened, my lord? The security checks which were given to the opposite party number 2, he did not return it. And my lord, later on, he filed a FIR. My lord, kindly come to NHR 1. This is the FIR filed by the opposite party number 2.
Yes.
Which refers to the subject cited above. I have the honor to state that the following named accused person who was a contractor and he taken many amount at various times from me with a promise of giving share of the construction work, and I have also taken amount from following person. Now at present, the said contractor is refusing to repayment of the said borrowed amount, and I am also facing many problems for this purpose to repayment the due which I have lended from persons. Therefore, I pray that you would be kindly grant this application and please issue an order to repayment the amount which is be due to and does oblige. Name of the accused person's contractor. This is the petitioner, my lord, the accused, my lord. Number 1.
Yes. Who is the petitioner?
This is Kabindra Narjari, ma'am.
The accused number 1. Please.
Yes, ma'am. And name of the landed person. Here, below it was written. Here, number 1 is Mir Ali, and serial number 4 it is written as Sofikul Ali and others. So, my lord, after filing the affair, the petitioner took bail from the district judge. In the bail order, it was categorically mentioned by the district judge that the case is on civil nature. Immediately, he handed over the checks to opposite party number 1 and he filed the case.
No, which checks? Security checks.
Security checks.
He returned.
I don't have any transaction with opposite party number 1. I don't have any date. Yes, it is of opposite party number 2, and kindly come to the bank statement which I have paid. Kindly come to NHS 7 page 39. On 4/3/17.
No, this is your story that he handed over the
Mine.
checks to.
Mine.
But in complaint, the allegation is that you had given the checks to the opposite party number one, respondent number one, and
It
it
is
was-
his allegation, my lord.
yes.
And and my lord, the FIR, which is a public document, my lord, under the Evidence Act, my lord, and that clearly shows that I have transactions with Miral.
No, that is a different case. That the FIR relates to FIR was filed by Mr. Mir Ali
This is opposite party number two,
against you,
my lord.
alleging some monetary transaction
My
in
lord.
which you got bail, and district and judge sessions court held that the transaction is of civil nature.
Civil nature.
That is a different case. But in the case which you are seeking to quash is filed.
It's,
But-
this is
Where
this
is the
is-
where is the complaint?
complaint is, my lord,
Which you are seeking?
at page 29, my lord.
This complaint is filed by
Sofikul
Sofikul Haq.
Hawkman.
It has no connection with Mir.
My lord, this is my case, my lord. I have handed over the security checks to that person, and he, after receiving the amount, he handed over those checks to this opposite party number one, and this case is filed falsely, my lord. It's a pure, my lord, case of abuse of process, my lord.
No, your plea is that the respondent number one has filed false case by taking checks from.
My lord. The opposite party number two and opposite party number one
But
conspired, my lord.
in
They
four-
conspired and filed this case.
in 482, how will we find out?
My lord, my lord, kindly consider one thing. That order, the affair, my lord, affair clearly states that this is the amount which I have not returned to the opposite party number two. And my lord,
Why have you made opposite party number two as a party? He is not a
my
party.
my lord, he conspired, my lord. He handed over the.
But he is not a party in that
my lord,
complaint case.
my lord,
He is not a party.
my lord. But he conspired with the opposite party
Then
number.
you have to lodge a FIR, file a complaint case
My lord, I have filed
in a
one.
482 proceedings without taking evidence, how will you find out it?
My lord, on that, my lord, I am relying a judgment of FS court, my lord.
Yes,
Here, my lord, I am relying paragraph 30, my lord. 30.
Vera?
Para 30, my lord.
Yes.
The proviso appended to the said section provides for compliance with legal requirements before a complaint petition can be acted upon by a court of law. Section 139 of the Act merely raises a presumption in regard to the second aspect of the matter. Existence of legally recoverable debt is not a matter of presumption under Section 139 of the Act. It merely raises a presumption in favor of a holder of the check, and the same has been issued for discharge of any debt or other liability. Para 31, my lord. The courts, here, my lord, courts, Supreme Court observed that courts below, as noticed herein before, proceeded on the basis that Section 139 raises a presumption in regard of existence of a debt also. The courts below, in our opinion, committed a serious error in proceeding on the basis that for providing the defense, the accused is required to step into the witness box, and unless he does so, he would not be discharging his burden. Such an approach on the part of the courts, we feel, is not correct. An accused for discharging the burden of proof placed upon him under a statute need not examine himself. He may discharge his burden on the basis of the materials already brought on record. An accused has a constitutional right to maintain silence. Standard of proof on the part of the accused and that of the prosecution in a criminal case is defined. My lord, I have brought the affair which your lordship can
No,
consider it.
that affair is a different proceeding. Here, the respondent number 1 has filed a complaint case under 138 against you.
My lord.
You are saying that you don't owe any outstanding debt
My
to that person. Now, at this stage, we can only see whether he has pleaded that there in his complaint, has he pleaded that there is a recoverable debt? Whether he has mentioned in his complaint or not. You are,
My lord, I have one GD entry, my lord. Or one affair with me. I have not, they inform me, I have not received. I will produce that, my lord. Let it be any other date, my lord.
because this Supreme Court judgment, which you are relying, how it helps you?
My lord, in the affair, I will come again.
That affair is a separate affair.
My-
You are not for quashing that affair. That is your case,
Yes. That
but you have to show why the court should interfere.
affair established one fact, my lord, that I had a date with opposite party number
Number 2, who is not a party in the complaint case.
but he handed over the security check to the opposite party number. That's why I'm placing that.
That is your case.
I'll satisfy your lordship.
You were, when,
First week of April.
heard. Stop. On request of Mr. G. Bosher, learned counsel for the petitioner, let this matter be listed again.
First week
In
of
the
April.
first week of April.
May I please, Lordship? With approval, I like to raise one point. Mention item number 15 is mentioned, is a very important matter, Lordship. They have not given me maintenance. I am coming on behalf of my wife here. Thing is that you have seen last 4 months, in spite of Honorable High Court's order, they have not paid the maintenance before the learned trial court.
You should have come in time.
Yes, Lordship, I offer my unconditional apology. It may be listed in the next week, either 27th or 29th or 28th of next week here. It's a very urgent matter. In
Today,
spite of Honorable High Court's order, they have not given the
No, no,
maintenance,
let me
interim
under-
maintenance, Lordship.
don't get excited. Let me
Yes.
understand what you are submitting.
In respect, I mentioned item number 15, Lordship.
Item number
15
15,
is a maintenance matter, very urgent.
somebody has
Yes,
mentioned
yes,
it
yes.
without informing you.
Without informing me, Lordship.
But we have been informed that you were some
No,
lady,
Not at all, Lordship, not at all.
Arun Das, she
Name is not on
she submitted that she has informed you.
Not at all, Lordship. They know my phone number. I have very constant relation with them, your other said learned friend. RM Das is on record, and the cause list I have seen his name.
We'll call it.
Yes,
seated.
yes. It is very urgent matter, Lordship. Wife is suffering a lot, Your Honor.
Oh, okay, no, she told that she submitted that she has informed you.
Not at all, Lordship. I am
Okay.
very free and fair, Lordship. So far this issue is concerned.
Okay, we'll call it
Yes, Lord.
this item.
Right.
serious.
Maybe listed in the next week, Your Honor. I am very much ready. On admission stage, the case
No,
is.
let her come.
Yes,
We'll call her.
yes. I am here also. Obliged.
Alert. Swami Dili की बड़ी बात है।
Maybe this, your lordship, this I have come against the order of framing charge.
Framing charges.
Yes. This petitioner before lordship was a businessman of Bokaghat. He's a local businessman. He has come contact with this response number 2, my lord, by way of.
Passed by the order dated 1/2/2024, passed by the learned court of additional chief judicial magistrate Tinsukia, in view of section 156(3) to register a case against the respondent number 2 and his officials. And thereafter, the in view of that order, the police officials of the Tinsukia police stations has registering a case against the petitioner number 2 and his officials under section 379 IPC, your lordships, and they are been at this stage they are been searching for this offense. Now the case has been arose, your lordships, way back on
No, which order you are impugning?
page the order dated page 1/2/2024, page 63, annexer L. May I read the order, your
No.
Lordship.
Before you read it, let me understand your case.
Lordship.
This order was passed under 156(3),
Dear lordships,
Direct-
directing to
directing Makum PS cases.
to register a case against the petitioner number 2 and his officials, your lordships. Petitioners are the finance company. Well, he has a duty to finance the new car and the old vehicles, your lordship. The order dated has said that today is the date fixed for necessary order. The complainants
Okay, now
now your
on a petition filed by
one Sumit Kumar Shah,
Kumar Shah,
lordship.
an order was passed under section 156 clause 3.
Lordships, without going through the entire records, more particularly the death Sumit Kumar Shah, the respondent number 2, from whom the vehicle has been purchased by him, that Ranjit Kumar Gupta, down below, by entering into an agreement before the notary public by the serial number 102 dated 4/5/2023. It is one of the most vital aspect of the entire matter. That agreement has been executed to transfer the land, transfer the vehicle from said Ranjit Kumar Gupta to the respondent number 2, that is the informant in this case. Now, the petitioners have given a finance of the vehicle vehicle to the Ranjit Kumar Gupta by entering into a hypothecation agreement, your honor. Agreement is dated 23/12/2022, annexer 28 and 45, your lordship. Whereupon the vehicle, they said Ranjit Kumar Gupta has surrendered his vehicle for non-payment of installment regularly by surrendering his vehicle, your honor. Annexer is page 50. Page 50 is surrendering his vehicle before the petitioners. And the petitioners given the loan to the said Ranjit Kumar Gupta on the proper following procedure and the documents.
What is the allegations made against you in your?
The allegation is that I have taken the vehicle forcefully. Now, if I read the FIR, Your Honor,
No, don't read.
page 70 is, Your Honor, page 70.
You don't read. Answer my query.
Page 64, last portion,
Page 64.
last portion. On 22/9/2023 at about 8 p.m., the said Binondo Moran had informed him over phone that some persons introduced themselves as officials of Sriram Finance, forcefully took away the said vehicle on the pretext the loan was pending against the said vehicle.
This is the allegation.
Yes,
This is
some,
the allegation. FIR is page 70, Your Honor. The
the
subsequent,
neighbor hypothecated the said vehicle as Sriram Finance. As such, they are not authorized to take away his vehicle.
now, if I go by the hypothecation agreement, dated Annexure E, page 28, it is crucial. The Ranjit Kumar Gupta, from whom the vehicle has been transferred, has having a hypothecation agreement with the petitioner's company, Your Honor. In Annexure E, page 28.
Just a minute. Sumit Shah lost the FIR
Sumit Shah is lodging a FIR
alleging that
alleging that his vehicle has been taken by the petitioners forcefully.
petitioner's finance company forcefully.
Forcefully.
That is the allegation.
That is the allegation.
Now, what is your case?
Now the person from whom the informant has purchased the vehicle having a hypothecation agreement with the bank,
With the bank or finance?
finance company, sorry, finance company.
Is finance company.
Yes, page 28, Annexure E.
Okay.
By from Binonda Moran, page 27, Annexure D. Kindly see the Annexure D, Your Lordships.
You are Ranjit Kumar.
No, I'm not. I'm for the finance company, Your
You
Honor.
are finance company.
And yes, and his officials, Your Honor.
So Binanda Moran sold the vehicle to Ranjit
Ranjit
Kumar.
Kumar-
Gupta.
Yes, and Gupta is financing from Sriram Finance Limited, and I have no objection regarding the same. He has been declared that he has no objection for if the finance company has been granted a loan in favor of Ranjit Kumar Gupta, Your Lordship. Then Ranjit Gupta has financed the company. And the hypothecation agreement has been done with the petitioners and the Ranjit Kumar Gupta, and he has abundantly undisclosed go ahead with the finance company to repossess the vehicle if the Ranjit Kumar Gupta has failed to pay the reinstallment. Article number 14 has clearly speak out that finance company has to take over the handover to take over repossession of the vehicle. But instead of that, the Ranjit Kumar Gupta has surrendered his vehicle in way back of 23/9/2023, Annexure H.
Where is the annexure?
Annexure H, page 50, Annexure H, page 50. On 23/9/2023, the vehicle has been under the possession of the Sriram Transport Company, that is the petitioners. Page 50. Last portion, I hereby voluntarily surrender the above vehicle to the representative of Sriram Transport Finance Company in accordance with the rights vested with the Sriram Transport Company Final Limited as per the schedule of the said agreement, whose terms and conditions I have violated by defaulting in scheduled payment of the above loan. So, in defaulting the
This is the typed copy. Where is the original?
original next page 51.
That is a printed standard form.
Lordship, he has duly signed, Your Lordship. Page 51. It is a type copy of 51, Your Honor. Now,
what-
now, Lordships, may I produce one of the agreement, that agreement 4/5. The informant has very well known about the fact that the vehicle has been financed by the petitioner's company. This fact has not been disclosed before the trial court. This is the agreement, Your Lordship, we have received lately, Your Honor.
Dated?
4/5/2020, this is the agreement of trial court. This is the agreement between the informant and the said Ranjit Kumar Gupta, Number 5 that specifically stated that the purchaser shall realize the loan amount of 3 lakhs to the finance company which is remaining outstanding at present. That means on 4/5/2003, the informant knows that the vehicle has been hypothecated under the petitioner's company. Subsequently, the entire procedure has been completed, done, Your Lordships. Subsequently, the impugned FIR has been lost by the informant before the police in connivance with all the peoples. That one Ranjit Kumar Gupta and the Binanda Moran. Right now, Binanda Moran is also one of the main person who has been involved in this entire matter. Then
No, your submission is that while obtaining the order under 156(3), the Mr. Sumit Kumar Shah suppressed some
material fact and the court below ought to have in unit the Lalita Kumari's case see that the parameters for the Lalita Kumari's case with the parameter has been laid down, has been complied with or not. That is one issue. And second issue, there is no intention or not bona fide in
what parameters?
Your Lordships, the Lalita Kumari's case has been given 111 that if the informations received does not disclose a cognizable offense, if you go by agreement, Your Honor, but indicates the necessary for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. Number 1. Now the number 4.
No, but it discloses a cognizable offense.
Now if you go by the the agreement dated 4/5, there is a doubt, Your Lordship. There is a clear cut stated that the vehicle has been under the finance of the petitioner's company. If it is finance company has been done, there the court below had ought to have verified or an inquiry whether there is a habitation.
No, inquiry would be required only if the FIR does not disclose as a cognizable offense.
There.
Now, whether the FIR has mentioned true facts or not,
Lordship,
that will be found only during investigation.
Lordship, but the thing is that the vehicle has been surrendered by that Ranjit Kumar before the petitioner's company. Number 1. And during
Fact was not informed in the FIR.
Lordship, and the delay aspect, the Lalit Kumar's case state that cases where there is an abnormal delay, there is a delay in lodging the FIR. There is an abnormal delay, laches in initiating criminal prosecution, that has to be taken account. Lalita Kumar's case specified that there is a delay of more than 25 days of lodging that FIR before the police station.
Okay, we are issuing notice.
And Your Lordship, I prefer a stay, Your Lordship, because
What stay?
Because
Stay of investigation.
no, Lordship, because in view of that FIR, Lordships, I may
No,
be
you want stay of what?
the impugned FIR, Lordships.
FIR cannot be stayed. Either investigation has to be stayed or
Lordship.
some proceeding has to be stayed.
But Lordship, may I pay this test because I am squarely covered by the Supreme Court judgment, Your Lordships. In Your Lordships, Saranjit Singh Chadda and others. This is and KK Mithai, and I'm squarely covered this judgment.
No, what it says.
Paragraph number 17 says the hire purchase agreement is in law is an executory contract of sale and confers no right in
No,
rent
But let us see whether those materials were before the court
or not.
or not.
Lordship,
Only then we can ascertain.
Lordship. Notice my God, Lordship, kindly further investigation maybe stop, Your Honor.
No, if investigation continues, how would you suffer? It will only reveal true facts. How are you prejudiced if investigation continues?
Lordship, if they pick me up and in view of
Then
the
you have other reliefs.
Lordship, then Your Lordship, the trial court below has passed an order observation that that according to OC is directed to Makumbi directed to register a case and investigate the case properly and submit the final form at the earliest, Your Lordship.
Yes,
That
that
has
would be good for you. True facts would be revealed.
Lordship.
It will not harm you.
Lordship.
So what you are apprehending?
No, because my entire staff, the entire petitioner staff will be in view of that FIR lordship, maybe behind the bar, your lordship. That is
So
one
for that, you have other
lordship.
options available. Heard, Mr. This is item number.
Three.
Heard Mr. H. Borua, learned counsel for the petitioner. Also heard Ms. B. Bhuya, learned additional public prosecutors. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners impugning the order dated 1/2/2024 passed by learned additional Chief Judicial Magistrate Tinsukia in CR case number 4/2024, whereby the officer in charge of Makum PSK, Makum Police Station was directed to register a case and investigate the allegations made in the complaint. Stop. Issue notice to the respondents. Since respondent number 1 is represented by learned additional public prosecutor, no formal notice need to be issued to respondent number 1. However, as regards the respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
Can it be an early lordship?
3 weeks. 3 weeks. The records would be required. The scan copy of the. What will you call for? CD?
Scan copy of CD, my lord. So you want to trial?
That's third one.
CD, my
Diary.
lord.
The scan copy of the CR case number 4/24 along with the case diary of, which is the PS case?
Makum PS case number 5/24.
Makum PS case number 5/2024 be called for. Then we have to give a fixed date
Lordship.
after
Makum,
3
no?
weeks.
Bihu Pisot, no?
Notice. Let this
22nd?
case be listed again on 22nd of April.
Lordship.
Raised to be directed, my lord.
The registry shall take steps for procuring this scan copy. Case diary or scan copy.
Deep level.
Mid-reader. The 483 application lordship for passing of the complaint petition lordships. Annexure A lordship, page number 16 lordship. For passing of the complaint petition. Page number 16. Lord.
What
is
are
the-
the grounds?
Basically, the Learned Trial Court, page number 27, was pleased to take cognizance under section 420, 468, and 471. The basic allegation against is the complaint petition against the accused number 1 lordships. That is the Navakanta Boishu lordship. There is no any specific allegation against the petitioner number, accused number 2, 3, and accused number 5 lordships.
Who are the petitioner before this court?
Yes, I'm the accused number 2 lordships, accused number 3, and accused number 5 lordships. The basic allegation against the complaint petition that the accused number was forged a bar of attorney lordships, and by way of that, he filed a miscellaneous application before the Learned Civil Court lordships. That is page number lordships. Page number 17 lordships.
Okay,
But-
we are issuing notice.
Kindly consider to the aspect of it, whether the 420, 468, 470 was issued, yes, was against the accused petitioner or not. There is no any specific allegation against the 420, against the petitioner under section 420, 468, 470.
No, we are,
The specific, my lordships, the specific allegation is was against only the accused number 1 lordship from the face of the required lordships. If you go to the complaint petition, there is the basic allegation against the accused number 1 lordships. Our allegation is against Lordship, page number 20, Lordships. Paragraph number 19, Lordships, paragraph number 10, Lordships. May I read, Lordships? That Sri Basudev Bakshi is on bail and the seed fund scam, and it was simply not possible him to leave Calcutta. Is the execution of the power of attorney at Udalguri district of BTAD in Assam requires the physical presence of Sri Basudev Bakshi at Udalguri, and he being under the trial of CBI court, Calcutta, it is not possible to Sri Basudev Bakshi to come Udalguri by leaving Calcutta without prior intimation to CBI to sign the said power of attorney at Udalguri, Assam in presence of notary. The accused number must have presented someone else before the notary, Sri Basudev Bakshi, which in turn have a result of difference in signature. Thus, the accused
Now
number.
summons have been issued.
Sir,
This is a complaint case.
yes, Lordship, we have received the summons, Lordship. The basic allegation is against the accused number 1, that he has forged an power of attorney by way of forging signature of Basudev Bakshi.
When is the next date fixed?
19/4/24, Lordships.
When?
19/4, Lordships. There is any specific allegation against the petitioner number 2, 3, and 5, accused number. No allegation against the, we have the forged the document, Lordships. The allegation is against the only the accused number 1, Lordships. That he has forged the document. And paragraph number 11. That the photograph of the Sri Basudev Bakshi address in the power of attorney is also moved on. The KYC document Sri Basudev Bakshi in the power of attorney is also moved on. An invalid document with the expired value. The signature of Sri Basudev Bakshi in the KYC documents are not matching with the signature of the Sri power of attorney. Is the basic allegation is the accused number 1. He has taken the.
But
There is no special.
against the petitioner, what are the statements?
Yes, Lordship. That's our allegation is that paragraph number 14, Lordships. The Sri Pulendra's accused number 2 and Sri Poetus Brahma accused number 3 had visited simultaneously tea estates to buy CTC earlier, and because of their unethical practice of doing business, they were prohibited to enter in the garden. On 10/1/2023, the accused number 3 entered into the garden with 10 guns with the along, while the accused number 2 was awaiting outside garden to arrange more guns with the objective to create law and order situation in the garden. Then the accused number 3 started shouting the field of the officer he would bring some prayer in for the high-rise limited to take possession of the garden, where the accused number 1, 2, 3, and 4 would get crores of rupees of gift from the Prague Infantry Limited. After 1 hour of mention skated by the accused number 3 outside the office of the garden, the staff of Sasikumar Tea Company Limited and assisted the accused number 3 and the guns to avoid law and other situations. That is the basic allegation against our petitioner. There is no allegation is against that we have committed or forged the document.
No, but where is the cognizance taking order?
Cognizance order number, page number 27, Lordships, Annex ID, Lordships. May
Just tell me.
page number 27.
420 is also there.
Yes. There is no any allegation against the petitioner. The basic allegation against the accused number 1, Nobakanta Boyso.
Yes. Miss Goya,
We are not the party respondent.
for this issue. We are issuing notice.
Until then, Lordship, the further proceeding may be still, Lordship. Here, there is no any specific allegation from the face of the record, Lordships. Face of the record in the complaint petition, Lordships. That we have committed a false document, Lordships. There is no any specific allegation. The specific allegation against the accused number 1, Lordships. Nobakanta Boyso. From the face of the complaint petition, Lordships.
And against 420 under
468 and 471, Lordships.
under section 420.
There is no allegation against. The basic allegation against our petitioner that we have created nuisance in the on 10/1/2023, we have created nuisance in the before the simultaneous.
Except para 14, there is
No allegation. Basic allegation against the we have
no
created
except
nuisance.
para 14. Where else your names are mentioned?
Lordships.
Except paragraph 14, whether your names are mentioned in the complaint.
Yes,
petition
Lordship.
anywhere
Paragraph
else.
number 16, Lordships. That the Sri Nabokanta accused number 1 in connivance Sri Pulin Das accused number Poetus Brahma Sri Siddharth Heli accused number 4 Sri Edward Berg accused number 5 is made a plan to create disturbance in the garden is to create law and order situation in the garden and to take illegal possession of the garden portfolio. Our the allegation is against that we have created nuisance on 10/1/2023 also. Thereafter, the learned telco was called for a report from the concerned police station also. That is an excessive lawsuits. Page number 26 lawsuits.
Heard Mr.
P. Dr. lawsuits.
P. Dr. Learned Counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely number 120 from the record. Praying for quashing of the CR case number 57/2023. Which has been lodged by the respondents. Stop. They have also impugned the order dated 4/10/2023 under 4/10/2023, by which cognizance of offense under section 420/468/471 has been taken against the present petitioners by the learned Judicial Magistrate First Class Goalpara. Stop. The gist of the case of the petitioners, in brief, is that the respondents, namely Asomi Industries Private Limited and number 2 Shri Diganta Das, had lodged a complaint case before the Chief Judicial Magistrate Goalpara, which has been registered as complaint case number 57/2023, wherein where is the allegation against the Nabokanta Das, Nabokanta Bosho?
Accused number 1 lawsuits, the complaint petition.
Where is the allegation?
That from the allegation of page number 18 lawsuit, paragraph number 2. Basic allegation is the paragraph number 7 lawsuit. That's in Nabokanta Boisho filed a miscellaneous petition on the strength of a special power of attorney dated so and so. The button is a moved one. Paragraph number 7 and 8 lawsuits. 7, 8, 9.
Okay. The basic allegation is against accused number 1 named in the said FIR, that is Sri Nabokanta Bosho, that he had forged a power of attorney dated power of attorney number 22275 dated 5/11/2022 and has used the same to has used the same stuff. However, no allegation of forgery or using a forged document as genuine has been made against the present petitioners in the complaint case. It is also submitted by learned counsel for the petitioner that the only allegation against the present applicant, present petitioners is made in paragraph number 14 of the complaint petition, whereby it is alleged that the present petitioners created some nuisance outside the gate of, outside the office of the, which garden, name of the garden is?
Simlitola Tea Garden.
Outside the office of the Simlitola Tea Garden, and there is no other allegation made to justify taking of cognizance under section 420/468/471 of the Indian Penal Code against the present petitioners. The copy of the complaint petition has been annexed as annexure
Annexure A.
Annexure A along with this criminal petition. On perusal of the said complaint petition, it appears that no specific allegation has been made regarding forgery or using a forged document as genuine, or for that matter of cheating by the present petitioners in the said complaint. Therefore, prima facie, it appears that the trial court took cognizance of offense under section number section 468/471/420 of the IPC against the accused persons, against the present petitioner, without any specific averment to that effect in the complaint petition. However, this allegation needs to be inquired into, and therefore issue notice to the respondents and call for the scanned copy of the CR case number 57/2023 from the Court of Learned, Judicial Magistrate First Class, Gwaltara. The petitioner shall take steps for issuance of notice on respondents by registered post with ID within 3 days from the date of this order, returnable after 4 weeks. Stop. In the meanwhile, for the reasons already mentioned herein before, the further proceeding of CR case number
57/2020.
57/2023 as regards the present petitioners shall be kept in abeyance. Let this case be listed after 4 weeks.
Objection.
Thank you, Your Worship. For FP2 application for quashing order dated 2/2/24 and 15/3/24, passed by learned additional session judge number 2 Nagaon. Simple orders annexure 11 and 11A at page 48 onwards. That's it.
Question. Where is the impugn order? At page
48 onwards. 11 and 11A annexure,
no page number.
page number 48, 11, and 5111A. Actually, Lordship, petitioner was arrested on 10/2/2023 and he was granted interim bail by learned Special Judge Nagao on the ground for treatment of his 90% locomotor disability daughter. And regularly his interim bail was extended. And he approached this Honorable High Court via BA number 80/2024, where this Honorable Court had order dated 10/1/2024 directed him to appear before the learned additional session judge Nagao on or before 15/1, but he could not due to treatment of his daughter.
Next date appear for what?
Yes. On
Ten
the next date is fixed on 10/4. 10/4.
4, yes.
10/4. Till that I may be protected, Lordship, and in the meantime I will appear.
Now what this order is, which you are impugning?
Issue phase NBWS against accused
Or
Munmun
NPW
Thakur,
has been
Iftikhar,
Iftikhar.
Iftikhar, for production on 10/4/2004 appearance.
You are,
Now also his daughter is in the GMCH.
now why you could not appear?
Due to treatment of my daughter. That is the ground. 90% locomotor disability, Lordship.
No, but when High Court has given you a
Yes.
time
then
frame,
on that,
if you fail to appear, you have to either extend that time by again approaching or seek
he
time
approached
from the
19/1/2024, he approached. So his mother. He could not appear due to treatment of his daughter. But on 2/2/24, Planet Session Judge rejected his prayer.
And by these two impugn orders, NBWA
Ah.
are issued.
Yes,
Okay.
Lordship.
You appear? Let
Lordship, at the face of it, he has violated Honorable Court's order, the condition stipulated in the bail application. That says
where is that order?
10/1 or order.
10/1,
10/1,
10/1. At page 45, Lordship.
40?
45, 45. At 47, 6 para, Lordship. 6 para. Considering the peculiar facts and circumstances of this case, the petitioner is directed to appear before the learned trial court on or before 15/1/2024. Apply for bail.
Medical document
Yes. 15, 50, 15A, 15B, 50A to Boras.
Heard, Mr. D. Kolita, learned counsel for the petitioner. Also on this lead, we are learned additional public prosecutor. The application under section 482 of the Code of Criminal Procedure, 1973, has been filed impugning the order dated 2/2/2024 and 15/3/2024 passed by additional session judge number 2 Nogao in special NDPS case number 139/2023, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioner has submitted that the daughter of the present petitioner is suffering from serious ailments including blindness of both eyes as well as 90% locomotor disability. And on the said ground, and it is submitted due to the said grounds, said reason, this court by order dated 10/1/2024 passed in bail application number 80/2024 had directed the petitioner to appear before the trial court on or before 15/1/2024. However, it is submitted that as the daughter of the, why you could not appear?
To the treatment of my daughter, Lordship. Now she is undergoing treatment at GMCH.
However, it is submitted by learned counsel for the petitioner that as the daughter of, as his daughter is still undergoing treatment Guwahati Medical College Hospital, and the petitioner was busy with the treatment of his daughter, he could not appear before the trial court on the, within the time which was granted by this court earlier. It is further submitted by learned counsel for the petitioner that considering the health condition of the daughter of the petitioner may be granted 15 more days time.
Lordship, 10/4 next date, till next date, Lordship.
Next date is fixed.
10/4.
10/4/2024. In the meantime, I will appear, Lordship.
It is submitted that the next date of sessions, which case
Page
number,
52, my lord, page 52.
case number is not mentioned.
Case number.
Next date of NDPS case number 139/2023
Four zeros are there.
is fixed on 10/4/2024, and he shall appear before the trial court on the said date. However, he has prayed for some impeding protection so as to facilitate his appearance before the trial court. Considering the submissions made by learned counsel, learned additional public prosecutor also does not opposes the prayer.
Provided it appears on the
Subject-
next date.
Subject to condition that he appears before the trial court on the next date. Considering the submission made at bar, as well as considering the health condition of the daughter of the petitioner, this criminal petition is hereby disposed of with a direction to the petitioner to appear before the trial court on 10/4/2024, and to facilitate such appearance, the operation of non-bailable warrant of arrest issued against the present petitioner by the trial court shall remain suspended till 10/4/2024. On his appearance before the trial court, the petitioner may make prayer for any relief to which he is legally entitled.
My lord.
With above observation, this criminal petition is hereby disposed of.
Public.
Item 6.
May I please, Your Lordship? Well, this is in 482 application against the impugned order, my lord. Before I'll go to the order, my lord, I'll just brief your lordship the background of this case, my lord. This is a case, my lord, pertaining to a PSC scam, my lord, the job for cash. Initially that the FIR was lodged in 2016, my lord, in Dibrugarh by one Anshumita Gogoi. Then thereafter, my lord, the investigation started. Many people apprehended. During this case, my lord, the 7 charge sheet has been laid down before this trial court altogether, my lord. 7 number of charge sheet. And during this 7 number of charge sheet, my lord, from the second search sheet, my lord. From the second search sheet, I was shown as a witness in this case, my lord. Prosecution witness. Yes. So thereafter, the cognizance of that particular charge sheet has been taken by the trials under 193. Lordship knows that this is a case, my lord, where
7 charge sheet in one case.
7 charge sheets in one case, one after another, my lord, the further investigation going on. Then the charge sheet has been laid down. The 7 number of charge sheet has been laid down. And I have been shown from this charge sheet number 2 onward.
In
From
second-
1 and 2, my
in-
lord.
In second charge sheet, you were shown as witness.
From there itself, I have taken as an witness of the prosecution, my lord. I'll show you before the lordship. Then the trial started. Charge has been framed against the other accused person. Then subsequently, my lord, suddenly, they have filed a petition. They have arrested me again, the investigation on the process of investigation, that the investigation is still going on, in spite of the fact that the trial has commenced, but that's not my contention, my lord. Now, again, they have arrested me. Thereafter, they have filed a petition, the prosecution, to change my character, to change my status from witness to accused, my lord.
When you were arrested?
My lord?
When you were arrested?
I am arrested recently, my lord. I'll give you the date, my lord. So my basic trust in this case, my lord, whether a witness who has taken cognizance of that particular charge sheet, because lordship knows, my lord, in these cases, my lord, this is a special court, my lord, and the special court takes the cognizance under section 193.
Okay.
Special court takes the cognizance because it's not a case of committal directly. Otherwise, every has to take the cases has to be committed in a sessions court. But this is a special court. It acts like sometimes as a magistrate, sometimes as a session judge. Both the powers they're performing. So directly he can take a special judge, directly can take a cognizance. And the cognizance is taken by the special judge under section 193 here. So he has taken the cognizance of those charge sheet where I have been shown as an witness. Then the trial started to charge has been framed against the other accused. Then the trial proceeded. During this trial, my lord, the investigation was also going on, the further investigation, and I have been arrested now. Then on
4/12/2023.
4/12/2023.
Yes.
Now, they filed a petition when I was in custody to change my status from witness to accused. Now, without any charge sheet, madam, that is without any charge sheet against me and without the going into the 319. There are either two provisions, my lord. Either it has to be charge sheet against me to make me an accused because already I was a witness in this case. Well, the trial proceeded, or I can only be implicated under 390. These are the only two provisions, my lord.
No, in this 7 charge sheet which were filed,
Yes.
in none of the charge sheet you were shown as.
No, I am a witness in this case, my lord.
In subsequent charge sheet also.
Yes,
you
yes,
were-
I have been witness
Okay.
throughout. There is no question that yeah, I am subsequently, because they also can convert in the one charge sheet, because the court has taken cognizance of that charge sheet, my lord. And lordship knows that the charge sheet is taken, the cognizance once it taken, he cannot go back that for trial court because it will be reviewing his own order, my lord, because he has taken the charge sheet entirely. And when he takes the charge sheet, cognizance, the accepted the charge sheet, he has taken it entirely. He cannot say, no, I'll take the part of the charge sheet. When the the court takes a charge sheet, he takes the offense of that particular offense, whatever the allegation, and the witness, he takes the cognizance of the entire thing. And on the basis of those charge sheets where I have been witness, the charge was framed, the trial started. Thereafter, suddenly, I have been arrested in the course of the further investigation. Then they have filed, the arrest is okay, my lord, okay, well, I'm not on that. Can now, without proceeding to 193 or without proceeding to 319, whether a person's status can be changed without following the due process of the law. Is there any provision to the CRPC apart from taking cognizance? Because only taking cognizance during the inquiry, the 319, your lordship knows, the 319 language is very simple. During the inquiry or during the trial, the court can implead a person who has been known, not shown as an accused, or whose name does not appear in the second column of the charge sheet. He can also be implicated during the inquiry or trial. The trial is 319. There has to be witnesses examination. Then thereafter there is a material prima facie. Then lordship can obviously take somebody as an accused, or in the process of the filing of the further investigation, any practice has been laid against me. But here, in that case also, this is the question here, the very pertinent question here, which needs the answer, because our High Court has answered already. There's one case that cannot be. Only 319 is the procedure here. There's one judgment only. The 319 is only procedure if somebody has already made a witness in the prosecution case. If he wants to be again charged sheet or he can be prosecuted, only procedure is the 319. Here, lordship, first kindly see the page 40. This is the charge sheet, my lord. Has your lordship got it, my lord? Oh, sorry, my lord. Page. Section. Sorry, my lord. Page 33, my lord. It starts from, my lord, 24.
This is the first charge sheet.
This is the second charge sheet, my lord. This is final report charge sheet 3/2017. Date is 28/7/2017. Now, lordship will find page 33, the list of witnesses, my lord.
No, this is which charge sheet?
This page 25, supplementary charge sheet, my lord. It starts from page 24.
Sure. Yes.
Page 24 starts. Now, my name appears in serial number 4, annexure A1 as a witness. Page 33, lordship, can you see?
Yes.
So this is my status, my lord. So this continues, my lord. Thereafter, lordship, kindly see page 86. Then again, second charge sheet has been filed, page 40. Now, the page 86, my lord, lordship, kindly see. Page 86.
Yes. 86.
86.
Yes.
This is the on 25/9/18. Court has taken cognizance of those two charge sheet, my lord.
And page 92.
And page 92 also. Because every charge sheet, there is a separate order of taking cognizance. Accepting that particular charge sheet, my lord, by the court. Okay. So, these charge sheet, one by one after, the court is taking cognizance of each charge sheet, my lord, where I have been shown as an witness, my lord.
Witness was also accepted.
And those,
Just.
so by accepting that CS, my lord, the my status of witness been automatically been accepted by the special court, my lord. Am I clear, my lord? Now, page, my lord, now 104, my lord.
Framing of charge.
This is by this order, the charge was framed against all the accused, my lord. Charge was framed. I was not in this case because there was no charge sheet against me.
The evidence starts.
104 is the charge against all the accused, my lord, who are facing trial now.
How many accused are there?
There are more than, my lord, initially, my lord, maybe
Presently, how many accused are
50
there?
something, my lord.
Excluding you.
50 something.
Okay.
There are 40 onwards, my lord. There are other officials also, my lord. Now, thereafter, my lord, the trial has started. Page 138. Just I will show that the trial has already been started. Not so very important, my lord, though I have shown it, but the trial has been started, which has been called for. So thereafter, my lord, I have been arrested. Lordship will find my arrest memo, page 146. I have been arrested, my lord. Now,
151 of the petition.
151 is the most important. 151. May I read, my lord? This is important.
Yes.
151. The prayer for permission to prosecute the witness, Lordship kindly mark it, the witness, namely Srimati so-and-so, so-and-so. With reference above, I have to honor inform you that during the course of investigation of the referred criminal case, several answer script of so-and-so, so-and-so examined along with the envelope so-and-so, so-and-so, so-and-so had been recovered from the residence of the chairman of the so-and-so, so-and-so under so-and-so police station under so-and-so. Subsequent to the recovery, so-and-so, so-and-so interrogated on 1/17 as to the ascertain the role of the recovery of the envelope with the name of her in the house of so-and-so, so-and-so. But her statement recorded under section 160 did not divulge any facts except the above recovery of the envelope. However, above related facts, name of the arrivals and the PW's number CNO1 being number Dibrugarh Precious so and so. That during the further course of investigation that the Srimati Sukanya Das posted deposed the statement under 160, but he concealed the various illegal commitment on her part of the getting job on the APSC combined country examination, the evidence gathered after her statement was taken during the course of clearly speaks of the prima facie involvement of the so-and-so, so-and-so, so-and-so. In being investigating officer, those so-and-so, so-and-so prudent to character and accordingly, she was asked to appear before the so-and-so, so-and-so. During the further investigation upon the scrutiny of the answer script on the regular so-and-so, the investigating officer seized 2 number duplicate answer script, book numbers and footprints so-and-so, so-and-so, the chemical examination, service number 2, the page 152, FSL report, handwriting apostate, duplicate answer sheet, share the accused Sukanya. Thus, was provided the fake answer. During the investigation, police seized 8 number of cases. We are not disputing anything. Thus, from the above fact, prima facie involvement of the so-and-so being found in the incident. From the above narrated facts, is therefore revealed that the dose Srimati Sukanya Das arrayed as witness. This is important. But after her further investigation, her role of an accused person has been clearly found. There should not be any occasion which resulted recovery so and so, so and so, so and so. Means examination, the APSC purported securing most recoverable amount, no person, so and so, Sukanya Das can be proceeded, investigated, diverse, different views from all the other material evidence. Hence, it is necessary to change the status of Sukanya Das witness to accused, then to prosecute into this instant case LS from element is depicted above. So they filed a petition, my lord, to change my status from witness to accused. So there is no charge sheet, my lord, though there is no 319 apparently against me, only simply a petition, my lord. Now we have also objected to that, my lord. Thereafter, my lord, the code, learned trial code, this is the impugn order, page 156. My lord, onwards, probably.
156 also.
156 started, my lord. (157) The learned special PPP Katati has submitted during the investigation several answers to main and so along with the envelope of the so and so. Sukanya Das was retained were recovered from the residence of the main accused Rakesh Paul. So the former investigation officer examined Sukanya Das but did not divulge any other facts except the above recovery of envelope on the other related facts. Her name and added as the list of PW. This is admitted, my lord, in the supplementary charge sheet number 1. However, in the course of further investigation, the case under 173(8), no new evidence has been found against Sukanya Das, and the present IO arrested her on produce in the court. Now, this is important. However, in course of further investigation of this case under 173(8), new evidence has been found against Sukanya Das, and the present IO arrested her in the produce in the court. There is no bar in law to change the status of a witness to an accused if sufficient material are found against her said witness. At present, IO is able to collect the sufficient materials against her, so it to become necessary to accuse necessary permission to convert Sukanya Das from a prosecution witness to an accused. Learned counsel, the Vedanta Quashing opinion on the submitted that during the investigation of the case, former investigation officer accused Sukanya Das was thoroughly examined and cited her as a witness, and the court accepted the charge sheet and the supplementary charge sheet. So the status of Sukanya Das cannot be changed only by invoking provisions of section 319 CRPC. So he is prayed to rejected the petition filed by the present investigation officer. It appears that the accused Sukanya Das was a candidate on so and so. This statement was recorded. I have perused the material, my lord. This is not important. Now, page 59. I have perused the materials collected by the investigation officer accused the Sukanya Das during the further investigation case. Also perused the statement of her recorded on the IO of the 161 CRPC in her statement under section 170. She was not disclosed anything material which is relevant to prosecution to establish case against the accused person on trial. It is difficult to understand as to why her name has been cited as a statement in the supplementary charge sheet number 1. However, during the further investigation, present I was able to collect sufficient material against her. The Criminal Justice 666 to maintain order, protect the individual right, promote the justice and investigation, executing the crime, punishing the officer. There is no bar in the law to change the status of a person from witness to accused. After consideration of material collected in the present by the IO, I am in the view that the interest of the proper effective investigation, change of the state of Sukanya Das from the prosecution witness to an accused is necessary. Hence, the petition filed by the present IO is allowed and the status of Sukanya Das is changed as an accused from the prosecution witness. So this is our case, madam. Now, the relevant question is that, madam, here, whether a person who does not, without any charge sheet, without going into 319, can quote so moto of his own change the status, madam. The CRPC is very clear, either on a charge sheet
No, this problem is bound to crop up in such cases where there is continuous
Yes, but that maybe
investigation.
that's a different issue.
No, I have a query.
Yes, but that's a different, that may, the question may come up, Manu. That's problem of us. But what is the solution? What is the legal process to bring all this person who's in further investigation? The only answer is that either you file a charge sheet against me when you are in further investigation, but the Lordship kindly remember, there is two parts. Some person may not be,
Now, where is the observation change
that is the 160, my lord.
after considering materials also?
Now, Lordship, there can be some charge sheet where a person may not be accused or may not be a witness.
Now, no charge sheet has been laid against the.
Yes, no charge sheet, ma'am.
No charge sheet.
So,
But I have a query.
yes, ma'am.
Assuming that a trial is going on
Yes.
and parallelly the further
Investigation is also going on.
And there you, the
Their
investigate-
materials comes against me.
No, some materials comes
Yes,
where investigating officers feels that further investigation is necessary,
yes,
but that person may be identified and accused, not charge sheeted accused,
yes.
whether that can happen.
Yes, that can happen. In case of accused, if he is charge sheeted accused, but not sent up, there may be some of them. They may be named in the FIR, but not sent up for the trial. Some of the accused, not sent up for the trial. One particular column is there.
No.
Then some of them may not be even sent up for the trial, absolutely blank. No indication in the charge sheet whether they are sent up or not. But during the further investigation, some material has been collected. The trial has already proceeded.
Now you are aggrieved by this observation that the status of
Yes.
Suparna Das is changed
From witness to
and
accused,
accused.
without any charge sheet, without 390. Is there any provision in the middle way? Is there any provisions of the mini trial in between in the CRPC, my lord? There's no provision. And the Lordship kindly see the most
No,
important
accused
part.
status of accused maybe that status.
I'm not
may-
an accused, my lord. First of all, I'm an accused witness in this case, where the cognizance has been taken as I'm a witness. Whole thing is different, my lord. I was not an accused in this case, my lord. Kindly remember it. I've never been an accused in this case. All charge sheet laid down. Never been an accused.
But as soon as some materials are found.
Yes. So what is the procedure? Procedure either, because your further investigation is going on. Arrest is a different, but changing the status of my status to making me an accused in this case.
No, the order is not clear whether charge sheeted accused or
No, it's
accused
clear.
tried.
No, without charge sheet. This is very clear, my lord. Without charge sheet, the only case is that they have found materials
against you.
against is only their petition. No, charge sheet, they are simply saying during the further investigation, they found material, so they want to change my status. This is not a charge sheet, only simply a petition has been filed.
So materials, that is not very clear. Materials to
Yes, even yes,
justify trial
yes,
or
even also that is a different part also. But even then, because I am holding a particular position at risk before the court. The court has taken cognizance of that particular charge sheet where I have been cited as a witness. Now, court can review his own order, because his own order is I am a witness in this case. He has taken the cognizance. He cannot review it also. There's a bar. 362. That apart, my lord, where is the procedure? Now only procedure for me to bring me as a witness, accused in this case. There may be some cases where the trial is going on and parallelly there is investigation is also going on. In that kind of a situation, only remedy for the court to wait for the search sheet. And not only that, then again, that search sheet under 173 and they have to take a permission from the court and the inquiry has to be done. That is the Supreme Court has said. Because I have been already discharged kind of thing in all the search sheet. I have been not made an accused. I am the witness here.
No, there was no material earlier.
There's no material earlier. So
It came to light later on.
later on, but how to bring me, how to change my status? Can automatically it can be changed tomorrow by filing a petition that I am now. That's not the procedure. Either you have to file a search sheet.
For that, some investigation has to be done.
Yes, investigation and the search sheet is required to
Look,
change my.
No. I am on a different line. You have to make me understand. Suppose during further investigation.
Yes,
The IO comes to
some material. will
some
come.
information
Yes.
that one of the witnesses is actually an accused.
Yes,
The material was not available earlier.
yes,
And to array him as an accused,
Accused.
to lay an supplementary charge sheet,
yes,
some further materials are required to be collected.
yes,
Suppose I am just giving a hypothetical situation. Then, and you are required to be arrested for the purpose of investigation.
for arrest the permission is not required.
So you are arrested.
Yes,
Now, what should be your status during the further investigation period?
the further investigation period at that time, because I was an accused, I was a witness,
Witness.
or I was not search sheeted or anybody. But you want to bring me as an accused now. Can only basis of a petition.
No, there is a thin line. Under 319, you can be brought as an accused
Yes,
if there is an evidence.
yes,
If there is evidence,
yes. But 399 are not applicable here.
not applicable.
So 399 too, that's forget about logic.
319 is not applicable.
Not applicable. They have not
Because-
gone into it. That is my case. Either you bring me under 319. Yes,
My query, let me pose my query. 319 is not applicable in this case.
yes,
378, 173 clause 8.
8 is the further
supplement-
investigation.
Supplementary charge sheet,
Yes,
supplementary report with additional evidence.
yes,
May be filed against you only
Yes.
when this collection
yes,
over.
yes,
Now, during the period
yes,
when the IO is collecting the evidence against you,
yes.
how will you be treated
Let us see.
during that period?
Yes, let us see. Let us say that I was arrested in that period, maybe.
Yes.
without the
Now
permission.
actually you are arrested.
I'm arrested. But the simply arresting and the arraigned me as an accused, both are, is it the same
No,
case, my lord?
no, you are not arraigned as a charge sheeted accused.
Yes, that is what I am saying. They can arrest, that is their procedure. In many cases, we have seen the person may be arrested. He may not be sent up for trial also. If he is not sent up for trial, if he is arrested during the preliminary investigation, he is not arrested and accused, then he can bring either 319, invoking 319 if the trial has proceeded. There is no in between, there is anything in the
No, 319 can be exercised if there are material, if
Yes.
there is evidence against you.
That is what I am saying.
Which
Just
is not, which
before
is
that,
not the case in the.
yes, before it is there any provision by which court can, I am here the court, I am not the police, what they are doing. I am the court, whether for the court, is there any provision to bring me, to change my status on the basis of an application without the search sheet? Without the search sheet, that is my case. Can the court Forget about the investigation. They can do anything, man. I'm not on that. But the court has to protect and court has to follow the CRPC. Is there any provision for the court to change my status only on the basis of a simple application?
No, when there are allegations against you,
Even then,
you
even
automatically
then,
become
where
an
is there the
accused.
provision, my lord, in between, my lord? Either charge sheet, how, when the court can take cognizance, my lord? Either charge sheet, because the trial has proceeded already, then you are going for the further investigation. On the further investigation, you can bring me as an accused in the further investigation with a charge sheet.
Yes.
But without that charge sheet, can then anybody, where is the provision of 319 then? What is the requirement of 319 then, my lord? There is no charge sheet requirement then, that anybody in the midst of the further investigation, tomorrow trial will proceed and tomorrow the floodgate will open, tomorrow X, 1, Z, anybody will come, they will look up that the tomorrow will make him accused, day after tomorrow X, tomorrow Y, tomorrow Z. Is this the provision, my lord?
Okay, okay, let me understand. I'm putting a query, then I'm
Yes.
taking a short break
My lord.
to understand the situation. Suppose charge sheet has been laid in a case.
Yes.
Where some of the accused are charge sheeted accused. Forget about this case. And parallelly, a further investigation is also on,
Yes,
like in this case.
yes,
During further investigation, the investigating officer gets some information against a person A
yes,
who was not charge sheeted.
yes.
And as trial has not
Lordship.
begun, nobody has deposed anything against him. 319 will never come. And as materials are not sufficiently collected so as to lay an additional charge sheet, the report under 173(8) is also not submitted. But during this period, when the further investigation is going on, and you have collected some preliminary materials accusing finger against you, against A. During that period, there may be requirement of your arrest, your custodial interrogation.
Yes.
And what will you be treated? How you
That
will be
is,
treated?
that is my, they may treat me like as accused.
Accused.
They may treat me. I'm not on their action, my lord. Because already they have paid me as a witness. And in the further investigation, there is some material. They want me to arrest. I'm not on that. The court has said you cannot even arrest. There's a, without the permission. I'm not on that also today. But my query is that whether the court can take cognizance of that particular petition and change my status without the charge sheet under section 173(8).
The court is not very clear.
No, that's clear, very clear. There are only a petition.
No, you have to make,
There's a
You have
clear, the petition itself says,
to reply to this query.
no,
Both-
my lord, please,
Both of you.
Lordship,
See, Lord-
if my learned senior friend has completed, then I'll start.
my lord, that order, the impugn order itself says, their prayer itself says, there is no charge sheet at all. Only they are changing the status in the midway. Till that, there is no charge sheet.
No, at page 160. Look at page 160, second line, 160.
160, my lord.
IO is allowed
Yes.
and the status of Sukanya Das is changed
Oh,
as an accused from.
from, yes.
Now,
On the basis of what, my lord? Their petition.
No. As an accused. Now, whether he is a charge sheeted accused,
No. That is why I'm saying, my lord. Take it from me, my lord.
if he is not a charge sheeted
No, my lord.
accused,
That is what I'm saying, my lord,
Accused.
again and again.
accused against whom the further investigation is on,
Yes.
then how the court is wrong?
How can the court can change the status? I'm not in, where I was a witness. How the court can in a midway take the cognizance?
No,
Without, my case is that without a search sheet, the court can change the status without the search sheet, madam.
No.
Because their further investigation is going on. Simply now they are praying a petition, they
No.
change the status.
No, you have not understood my query, which I posed. The status of accused may be before charge sheet also.
No, their status, whether the court is bound by by my lord, the allegation. They will say he is an accused, so court will accept he is an accused. Is this the law? In 313, the court, the prosecution will say that he is the accused, so make him implead him. That's not the law. The Supreme Court also said, if he is a discharged, not even accused, there's a provision laid down. You cannot buy of your own. Court cannot take the person as an accused of his own in a midway.
I am taking a short break of.
Lordship. Lordship, for the end of justice, my lord, may I pray your lordship may call for the scanned copy of the LCR, my lord. And your lordship, why these persons have been booked as an accused? After the division bench has directed the government to form an SIT. Prior to that, your lordship, there are saying in Assamese, my lord, Puthi Kholionas have been caught, my lord, but rope oralis have been slipped away. And when the SIT was formed, my lord, these persons have, lordship, the involvement came to light. Your lordship may kindly have a look at page 160, my lord, of the petition. Last line.
So in this case, actually, the counsel submitted that the FIR was lodged by one Anushita Gogoi.
My lord.
That was in regard to a specific offense.
My lord.
Thereafter, whatever allegations are made, all are clubbed together.
My lord.
So case has become bulky.
My lord.
Now,
Lordship, may I submit the last line of the petition, 160?
okay, let him complete.
Now, that's the lordship queries that probably my understanding that they have already changed my status during that particular further investigation and they have made me an accused. So court has also taken me as an accused.
But it has not clarified. Accused against whom a charge sheet has been laid and accused against whom charge sheet is yet to be laid.
Yes.
You are in the
Yet.
second category.
Yet to be laid. Yet to be laid. If
So you
there
are an accused against whom charge sheet is yet to be laid.
yet to be laid, but I am as a witness where the cognizance has been taken in that particular search.
That is a difficult.
That is one thing. Now, the lordship knows it. The further investigation can go on in any case. But during further, if the material is collected, there is no scope for any petition in between in the further investigation. They have to lay the charge sheet only under section 173A. Then they can bring additional accused. No problem. No query about that. Whether court takes that cognizance of that additional charge sheet, that's a matter is different. Court may or may not. But they can lay the charge sheet under section 173A, further investigation, further charge sheet. In this case, there is no, though there is a further investigation, no charge sheet has been laid down against me. Simply one fine morning, they arrested me. Okay, let them arrest. I'm not on that also. Then, during my custody, they filed a petition that we want to change the status from witness to accused. And that prayer was granted by the court without having the charge sheet under section 173A. Is there in between, is there any provision in the CRPC to take somebody accused when the trial has commenced in one part, in the midway by the further investigation? Okay, further investigation, I am not on that. Further investigation they can carry out. Not without the permission of the court also they can carry out. That's not an issue. But if there is a further investigation, you have to lay charge sheet against me. Then we can, if the court take cognizance, then I can be an accused. That's a different. But here, the court of their prayer without being a charge sheet laid down, the change of my status from the witness to accused. My already cognizance has been taken. That you can mark it also. Now he has reviewed that particular cognizance also. Can he do it so? 319 is a different. 319 is a totally different. During the evidence or during the inquiry. What is that purpose of inquiry? That has been clarified. What is the meaning of that inquiry in 319? Otherwise, 319, it appears that when the evidence started, but the Hardeep Singh case, 319 has been elaborated. The similar query was there. Similar kind of thing. A person has not been charge sheeted. Then subsequently, in the supplementary charge sheet, he was charge sheet, but trial has taken. Then what happened, my lord? There's no material, he was discharged. Then again, further investigation was going on at that point of time, similar to in this case. Further investigation was going on. Then, the charge sheet has been, without the charge sheet, court wanted to proceed him against him under 319. Now, further investigation also going on, and now the witnesses has also stated something against him. Even then, court has said no. You cannot straightway go, you have to cause an inquiry under section 300 subsection 5 before airing him as an accused. Court has gone into that extent. A person who was not originally as an accused. So court there's two options for the court. Under section 193, cognizance has to be taken under the charge sheet or under 319. There is no other provision in between.
Then I can be an accused for the court.
And 193 cognizance can be taken only
When
additional charge sheet has been.
either in the charge sheet, because the court has to take the cognizance of the charge sheet, not a petition man. Or on the basis of, now this, before I'm going to the similar, just I'm placing the one judgment before your lordship of our High Court.
No, before citing judgment.
Well,
Now, your grievance is only regarding change of the status.
change of the status and that how they can do it. The entire proceeding, my lord,
Lordship,
that-
may I pray, Lordship, maybe please to fix the matter 27. I'll make my argument on that regarding that issue. Whether without laying charge sheet, a person can be arraigned as an accused when he was cited as a witness. My lord. A limited
No,
aspect,
Lordship.
I'll satisfy.
Before that, what,
lordship kindly see this judgment also,
now what relief you are seeking in this
that the impugn order has to go back.
status?
That status, that impugn order has to go back, my lord. That has to be set aside. That is only relief. They can further during the 319, let them make me accused. I have no grievance. With following due process of law, that's the rule of law. We are only on the rule of law, my lord. And lordship knows the Nazir Ahmed famous case. Because this is a case where the stringent punishment has been prescribed. And when the stringent punishment has been prescribed, the procedure, strictly has to be followed. There are 7 catena of judgment, my lord. I don't need to place all the judgment. Lordship knows it very.
Lordship, just
Now-
one line, page 161. Why she was arraigned as an accused, my lord? 161. Just
not,
kindly have a look.
not lordship kindly mark it. Lord. I'm not disturbing them. Let her submit whatever they submit in the next day. Kindly mark it. I am not on the whatever the material collected. I am not there. Let them material collect of thousands of material. I am not bothered about whatever the material they have collected. at the further investigation. But what is the procedure for adopting me as an accused?
So,
That
yeah,
is the
on
question here.
27, I'll satisfy whether it can be done. At the
So-
face of it, it is an illegal order, it will go, my lord. I'll satisfy my
So
your
lordship,
lordship on the
kindly
next
see, this is
date.
the judgment of our High Court. It's similar, this one. The same thing has happened. Paragraph 2 onwards, my lord. May I read, my lord?
Yes.
So and so learned counsel for the petitioner has died before this in court, the relevant document has been filed, he made a submission that petitioner herein referred as witness number 34 in the charge sheet. But however, learned trial court, after perusing the charge sheet at the time of taking cognizance on so and so, taken cognizance of the offence under section 6 against the 53 accused person, and has also equally held the present petitioner as accused and direct him to face the trial. The relevant portion on the reported
Which
here.
para you are reading? Para?
3.
Para 3.
Okay. Yes.
So in this case, even the charge sheet was laid down. Oh, without him. Then the court wanted to take him. Here the court. I was shown as a witness in the charge sheet, similar to this. Here he was charge sheeted witness number 34. Has your lordship got it? Page 34. Witness number 34 in the charge sheet.
Yes.
But however, the learned trial court, after perusing the charge sheet, at the time of taking cognizance on 11/1/19, has taken cognizance of the offence under section so and so against 53 accused person, and has also equally held the present petitioner as accused and direct him to face the trial. So it is a suo motu. Though I was a witness in this case. Now,
But in this case, you are not directed to face the trial. Only status has been changed into.
yes, let us have been
Court
changed.
is waiting for the final report, additional
But
report. on one
That,
side.
yes, status has been changed from accused. Now I have been made an accused in this particular case. In the trial.
Without the charge.
Not in the trial.
Yes, yes, in the trial. Trial is flowing now. This is the trial. I am facing trial now.
This is order under.
Order itself. Now I am accused in this trial.
Not in this trial.
I'll come to that, my lord. This is the order has been placed. Even that be so, my lord. Can he change my status, my lord, of his own? Once you have taken cognizance as an with me as a witness, can he revise his own order with a simple petition, my lord? Who is an accused, my lord?
Against whom?
Either there has to be a charge sheet, my lord, in the
No,
court.
no. Even.
Only otherwise, where is the provision for declaring me as an accused in the if
No,
there is nothing?
No, there is a difference in this case.
No, whether court declares a person an accused during the investigation, my lord.
The necessity.
Is there
Yes,
anything, my lord? Just I want to for my satisfaction. Is there anything for the court to declare somebody as an accused during investigation, my lord?
Specific.
So it is up to the investigation, whom they make an accused, whom they not. It is their prerogative. Even court even cannot direct also. You make so and so an accused. That is not the. That's not the court has no. Even the Supreme Court can't even. It is the IO's prerogative whom he makes accused. Court will see material. On the basis of material, on the basis of charge sheet, on the basis of evidence, the court can either in inquiry or in during the trial. Here is neither the inquiry is pending. That inquiry, if the court wants to change the status, if it is considered to be an inquiry, there has to be an inquiry first. Then inquiry has to be caused under section 300 subsection 5. Not only the petition. If, and this is not an inquiry under 319. Midway, there is no provision at all in the CRPC. At least I have not found it. There may be a new provision in a new CRPC. I have not gone through.
Lordship,
But the.
May I submit on 27, my
You
lord? I'll
submit,
satisfy.
Did I say anything that?
No,
you
no,
are
you have not said
Then-
that there
then-
are other matters, people are sitting here
The
waiting
court-
for
let
their
the court
cases.
decide, let the court decide.
Lordship, because
Lord,
on that
let
day,
the court
on
decide.
that day, your lordship will
Yes.
decide. Because
Lord,
passing
I'm-
of interim order, your lordship is praying for the interim order after
No.
hearing me.
He has not stated anything regarding interim order.
I'm
No, he's
looking like
praying
sitting.
for, he's praying for interim relief, my lord.
Let her put the objection first, then I will submit.
He has already taken 30 minutes of this.
I may
conversation.
take the whole there. Is there any bar? Unless and until. court-
I am making the submission before the honorable court, not to
Let-
anybody.
let I can argue if this, so long as the court allows me, I can argue. If the court stops me, I'll stop here right now.
Mr. Bora,
If
continue.
the lordship please thinks that I have taken the time,
You have-
unnecessary, I'm taking the time of your lordship, I'll stop right here, my lord.
No, you continue. You have made your point.
No, I'm
That-
coming to the next point. Well, I am not objecting that she should not be given opportunity in this that. Why she is interfering in the media? I'm not objecting to that. I'm completing whatever I can complete till 1 o'clock.
Your point is 319 is not applicable.
319, they have not invoked,
Not
that
in-
stage has not come.
Additional charge sheet is not there.
Additional charge sheet is not here.
Therefore, court is wrong in changing
Yes.
the status from witness
Yes,
to accused. That is your submission.
that is, and that is exactly that judgment has said in our High Court. If there is anything, the last paragraph, lordship, kindly see, I'll not bother, next day I'll read, my lord. Yes. Paragraph 14. Returning to present case, the similar provision, my lord, so similar facts, my lord. Turning to the present case, it is found that the magistrate hearing immediately after filing the charge sheet of his own opinion has laid the present petitioner, who was otherwise witness in this case, made him an accused and summoned him to face the trial as an accused, which is not at all correct position of law, as indicated in the aforesaid decision, as well as plain reading of 319 of court, as because evidence is not to speak about the role played by the present petitioner, and it is far below the stage so to pass the role of the conduct of the present petitioner in the entire prosecution case. Learned Standing Counsel CBI has also considered to the aforesaid status of this case, and thus cognizance has been taken in the premature stage by the court itself, whereas the court is ample power to invoke such provision in the proper state. Considering the entirety of the matter, legal position discussed above, the court is of the opinion that the impugn order dated so and so, so and so, so and so. So far regard to the present petitioner, his concern is liable to be interfered with into, and the same may be accordingly set aside. The present of the status of the petitioner, now lordship kindly see, the present status of the petitioner will be simply a witness as the charge sheeted. However, the court is at liberty for invoking section 319 CRPC at the appropriate stage if such evidence emerge against the petitioner. This is the similar thing. Here also court has taken show motos. He was a witness in this case, taken cognizance, show moto against him. Court said, no, this is not the proper stage, only 319. But I am even said, also before 319, 193 also can be invoked, taking somebody as an accused while taking cognizance. But for that, there has to be a charge sheet, because 193 language is very clear. So I'll continue, my lord, in the next day, on the 22nd night, 27.
Third, Mr. A.N. Bora, learned counsel for the petitioner, assisted by Mr.
B. Quashing.
B.
Quashing.
Quashing, learned counsel for the petitioner. Also heard Miss B. Via, learned additional public prosecutor. Your submission is still, you have still
Yes,
to
yes.
make.
There
Before
are
she
2-3
starts,
judgment also.
before she starts.
Yes, 2-3 judgment, my lord, because her lordship is not,
At
that point I have not clarified, that the other points, how the court can invoke the 319. 193,
Then you, on the next date, you
yes,
answer my query, one query.
that's my lord.
you said that there is no provision for assigning a person as an accused in the CRPC by the court, In this case, the trial court has only changed your status from witness to accused.
And
With
they
no-
allowed their petition to make an accused in this case. There's a
Right,
prayer
yes,
in the
in
trial.
this- In this case. No,
Yes, madam. Their petition has been allowed. Petition 150, page 152. Accused in this case.
now my query is, which you should answer on the next date. How a person
Yes,
who was earlier cited as a witness
yes.
and against whom sufficient evidence is yet to be
That
collected.
is why I'm saying 173 subsection 8. Further report.
No, before
Before
filing-
this, there is no provision now.
before filing of that report,
There is no provision as such, my lord.
no provision. My query is, before filing of that report,
Yes,
how he would be treated as?
he will be treated maybe by accused, might by the prosecution. But for the court to take him as an accused, here court has taken him as an accused. Without a report, that is my case. Prosecution may arrest him, may accuse him. That's a difference. It is not, I am not the aggrieved by the prosecution, my lord. I am aggrieved by the impugn order. Where that the prayer of the prosecution has been allowed to make him an accused in this case. By virtue of that impugn order, out of the blue, without the charge sheet, I have been made an accused.
No, at which page that observation is made?
152, their prayer.
No, not prayer, the observation by court. That you are treated as an accused.
160 is the, and the prayer of the whole petition has been allowed, my lord, before that.
No, where is that observation of the court?
159,
159.
last paragraph. I have considered the material collected by the present IO. I am of the view that the interest of the proper
Okay,
investigation.
160. Okay.
159, my lord, last paragraph. And he has admitted that investigation is still going on against me. Look at that. I am the view that for the interest of proper effective investigation, the change of the
Okay,
status of
This
criminal
last paragraph you have to explain properly.
is necessary. Hence, the petition filed by the IO is allowed. This prayer of the IO to make him as an accused in this case has been allowed. Prayer of the IO, Lordship will find at 152. Lordship, kindly see.
On the request of learned counsel for both the sides.
That is the last line. Has the Lordship got it?
On the request of learned counsel for both the sides, let this matter be listed again on
27.
27 March. in Boston, Florida.
Oblast.
Item 7.
May it please your lordship. My lord, the petitioner before your lordship is an advocate and the husband. The wife has filed, the respondent number 2 has filed an affair. Ultimately, it's culminated into a charge sheet. Page 17, madam. Page 17 is the charge sheet.
Yes. Yes.
And my lord, the charge sheet says that at page 18, during investigation, a prima facie case under section 341, 294, and 323 IPC have been found well established against the FIR named accused. I am the husband, my lord. Now, your lordship.
Your
may-
wife has filed an FIR against you.
My lord, and this is the charge sheet where this is the offense which has been taken. And the cognizance was taken at page 21, page 21. Cognizance taken, 341, 294, and 323.
Okay.
My lord, now your lordship may turn to page 24. This is from the government to the public prosecutors of the state. An additional public prosecution. Authority letter for withdrawal of petty minor cases under section 321 CRPC. And the exceptions are, my lord, a number on Roman 1, molestation, sexual assault, POXO case, corruption, embellishment of public fund, NDPS Act, armed explosive, case registered under 498A IPC, 304A, 379, offense relating to coins, government stamp currency, unlawful activities act, organized crime, cattle smuggling, super smuggling, coal smuggling, cases against MP and MLAs. The petition was filed by the public prosecutor, that is at page. My lord, it is at page 26. Before the learned court below. Your lordship has already has seen that the offences were under section 341, 294, and 323. They are all below 3 years. Your lordship has gone seen the petition at page 26. The learned trial court at page 28 held the offence against a woman, hence I am not inclined to allow the prayer of withdrawal of the case. Now, this
The withdrawal prayer was made by the
public prosecutor. And the withdrawal was not allowed because it is against the woman, but the exception does not say. Exception only says against 498A, molestation, sexual assault, and POXO Act. Then I find a revision before the session court. Session court also held that it is against the woman. That is why it will not be allowed. But under exceptions, it is against the woman, it is not said as such. Well, that is why I am before your lordship. The opinion of the learned at the page 28 is the trial court's order.
But the merely because the public prosecutors were authorized to.
Well, 321, it is true. Only by a state government direction, public prosecutors. But only thing, my lord, there should be an application of mind by the court against the woman, or there is nothing in the SOP where it says that any against woman, it will not be taken into consideration. They have specifically stated if it is a molestation case, if it is a case of 498A.
No, that guideline is for public prosecutors only,
Public prosecutor,
not for the court.
not for the court.
Court can consider anything.
Court can consider anything.
Court has reasoned it that because of the fact that this is an offense against.
And
women.
the reason is, another reason is of the court, that you have not made the informant as a party. That was the reason. If you have not made the informant party, but the informant was there in the trial. Well, she could have been summoned to appear before the court. My only prayer at this moment, my lord, if your lordship permits this to rehear the matter again by the learned trial court, asking the woman to come before the court and decide it again, madam. That much only.
Info party বনাইছে
Yeah, you have made her a party here. My friend, sister is already.
let the notice go, let
Where your wife stays now,
No, she is also advocate of a future bar. Both of us are advocate, both
you
of
are
us,
together or separated.
my lord, we have separate. But that is, this problem started with the court campus. That is what, my lord.
Then. Okay, we are issuing notice.
yes.
My lord, at this moment, because evidence stage, if it process, then because we have impact. So
Your
let that
wife
be
is also an advocate.
advocate.
Without hearing her, we cannot.
My lord, that is,
If
my lord, without hearing her, but if the case is there, then my lord, this case has become infectious. There is no problem. There will be no solution to this. That is why, my lord, if it is evidence test, for time being, my lord, let the wife come. If both of us can join hands, my lord, the matter will be over.
No,
It's petty case.
let your wife come, then we
Yes.
will hear your
My lord, because in the meantime, my lord, evidence stages go argumentative, everything. My lord, your lordship knows once
Things don't move so fast.
because your lordship knows here the stages are of evidence stage. Because it is a case, minor petty cases below 3 years. So that is why, my lord, your lordship, these are the cases where it
No, you don't have a very strong case. Your only ground is that because PPs were authorized by a letter which
my lord, my case is when the trial court held that it is only, it's true. But my lord, one judgment that I found, my lord, I don't know. This judgment, my lord, your lordship will look into. Yeah, my lord. About 321, my lord. There are 10, my lord.
what it says.
May I read it slowly, my lord? There are 10.
Now you may tell me the crux.
My lord,
What is the gist?
case is, my lord, here about 321 withdrawal by prosecution, when can be allowed? Necessary consideration. The considerations are there, para 10. This will, my lord, withdrawal will bury the dispute. Para 10, my lord, your lordship may find.
Not without hearing the,
Not because by the time they will take notice and come, my lord, the case will proceed. And after, my lord, 8 months, 9 months, it will be fixed for hearing.
we will fix a short date.
Short date, my lord, it will be difficult, they will not come, my lord. If she doesn't come, your lordship knows, it takes time. 24 matters will not be listed for hearing, my lord, immediately.
Yes.
My lord, because it is a private, small petty cases, my lord. My sister is also knowing that they are husband, wife. They both are practicing. That will not be, this will bury the dispute between them, my lord.
No, your wife is entitled to get notice.
We will send,
Not-
your lordship will
Not
send
at
the
her
notice.
back.
Your lordship will send notice to the second respondent. Only thing, my lord, till then, my lord, the case may not.
Lordship, may please to issue notice fixing the next date for consideration of the interim order. Lordship, short date,
Because if she doesn't appear on that day,
petition
we'll
লিখিব
consider.
তলৰ photo.
Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, also heard Ms. Reed Meyer, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure has been filed by the petitioner impugning the order dated 30/5/2023 passed by learned judicial magistrate first class Kacha in PRC case number 2745/19, whereby the prayer for withdrawal of the case by the public prosecutor was declined by the trial
because,
court.
my lord, if your lordship permits me, session court previously stayed my case. Thereafter only rejected, because the lady was not made a party. There was a stay order. So that is why I pray for a stay order. My lord, session court gave a stay order. Only because not made a party.
You are also impugning the order of the Sessions Court.
My lord, both the.
The petitioner is also aggrieved by the order dated 29/2/2024 passed by learned additional session judge FTC Kachas in revision petition number 96/2023. Issue notice to the respondents. Since learned additional public prosecutor appears for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuing the notice on respondent number 2 by registered post with ID returnable on 23rd April.
Long time, my lord. Till then, my lord, if she comes and oppose, my lord, everything goes, my lord. If she comes and oppose, I will withdraw the case.
Actually, I am not convinced that you have a strong case.
Because my lord,
Yes.
the learned session judge held because I have not made a party. That is the reason. That is, they have stated, my lord. That because 321, you have not made a
Ye-
party. If she would have come, we would have solved the issue. There was a stay order. There was a stay order. Now, if it's not a stay order is given, my lord, then everything will become infructuous. I know, my lord,
It
this
will not
case,
become infructuous.
You may
case,
inform the learned trial court below regarding pendency of criminal petition.
my lord, that observation may be informed that pending.
The, on 24, the prayer for interim relief would be considered only after service of notice on respondent number 2.
And my lord, the trial court may at least consider this, my lord. Otherwise, if it is next date is fixed for argument, my lord, after evidence. Then, my lord, everything,
At what stage it is?
evidence stage, my lord, is over, evidence is over, argument stage, my lord.
Where is the?
Huh? Okay. Okay.
It is fixed at argument stage here. Where is the?
Page 24, your lordship may look into it. Page 24.
Page,
24, my lord.
page number?
24.
24 no.
23, my lord. PWs.
Lordship, 35 is the next date.
35, 23.
Oh, it's gone.
It's 23.
What has happened after?
Thereafter, my lord, evidence, there was a stay order, man.
No, where is the
Audition idea.
last order?
My lord,
Where is the last order?
lost order because there was a stay order because the first order there
After
was a stay.
vacation of the stay, where is the last order?
Well, after that is not there. Well, after the stay was vacated in 29/2/24, 29/2, just few days back.
Where is that order?
It's a annex, well, 29/2.
29/2?
That is at page 37, learned session judge order.
No, not second judge order. Where is the order of trial court?
Trial court, my lord, thereafter, my lord, trial court has not proceeded. We have come over here.
So it will not move so fast. If trial court has not yet started, let it be on which date?
And but
25.
we'll send dusty service, then it will be shorter date because after 4 weeks, my lord, after 4 weeks.
Dusty service, if your relationship with your wife is not very good, she will not receive your notice. Let it go.
Because, my lord, without a stay order, I know, my lord, what I have seen for so many years, 42 cases become infructuous. So nothing will happen because everything, my lord, after the end of, they will come, they will file objection, they will file affidavit, come for admission, go for another date. It will be after 8-9 months. In the meantime, it will proceed. Because somehow when it is a FIR or charge sheet is challenged, I'm giving a, my lord, a situation where it is no stay is given.
No, for stay, you have to make out a case.
My lord, here what we have made out a case, learned session judge.
If you insist, I will consider and I will pass orders on merit on your stay.
Only thing is this, my lord, only because learned session judge held that we have not made her a party that was rejected.
No, that logic of the session judge is different, but you are relying on the notification of the government to the public prosecutors, which
Correct.
is not binding on the court.
Not binding on
Court
the
can consider whether to allow withdrawal or not on its own, basing on.
correct, my lord,
material-
321
It is available
absolutely
on
clear.
record.
And on that count, I don't think you have a very strong case.
My lord, then
So wait for you. 20.
in shorter date, my lord,
23/4 holidays what is happening?
1 month, my lord. All right, my lord, 23.
Lordship, can you pass over the matter 40 days? Maybe fix on 28/3.
Heard Mr. R. Islam, learned counsel for the petitioner. He prays for an adjournment due to what fact?
File an additional affidavit, Lordship.
As the petitioner has filed an additional affidavit to bring certain facts on record, the prayer is allowed. Let this case be listed again on after a week.
Date may be fixed 28/3.
28
28/3.
on 28/3.
May I please? This is the second bail application. Earlier bail application was rejected on the ground of maintenance. This is relating to child marriage. And 374 was there.
Where is the rejection order?
My lord, page 33.
May I please, your lordship? I think this revision, lordship, is against the order of the appellate court, lordship. The trial court, lordship, convicted the petitioner for 6 months, lordship, and to pay compensation of 8 lakhs, lordship.
Okay.
And this judgment was affirmed by the appellate court, lordship.
NI Act.
NI Act, lordship.
Okay, we are issuing notice.
Also, some protection may be given, lordship. If the complainant comes, lordship, we will make an
we are-
endeavor to compromise the case, lordship.
No, it has to be admitted, sir. We are not admitting it
Yes, lordship, lordship may issue a notice, lordship.
because for admission also, you have to pay 20% of the,
Yes, we have paid already 20% before the sessions closed, lordship.
okay.
At the time of appeal, lordship, we have paid some amount, lordship. As per my instruction, lordship, today which I have received, lordship. So we have paid, I think, 20% before the sessions. closed.
Now, when the judgment has
Because they
been,
will start the execution, lordship, on this.
that has been upheld,
Yes,
so whether that 20% has been paid to the respondent,
yes, lordship.
enact. Enact. No, we are issuing notice only. Heard Mr.
M. Ahmed, lordship.
M. Hussain,
M. Ahmed.
M. Ahmed, learned counsel for the petitioner. This application under section 397/401 of the Code of Criminal Procedure has been filed by the petitioner Jitumani Das, impugning the judgment dated 18/12/2023 passed by the Court of Learned Additional Session Judge within bracket FTC Borpeta in criminal appeal number 28/23, whereby the judgment passed by Judicial Magistrate First Class, Borpeta on 18/12/2023 in NI case number 217/2022 was upheld. By the said judgment, the present petitioner was convicted under section 138 of the Negotiable Instrument Act and was sentenced to undergo simple imprisonment for a period of 6 months and to pay a fine of is it fine or compensation? Pay a fine of fees 6 lakhs, which has to be paid, which was directed to be paid to the complainant as compensation. So issue, you are on bail,
Yes, lordship.
previous bail.
Yes. Lordship, that compensation, lordship, it was not 6 lakhs, it's wrong. Typing, lordship, it's 8 lakhs. 8
Make,
lakhs in the judgment, lordship, I have checked.
make it correct. 8 lakhs. The issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with the AD within 3 days from the date of this order, returnable on after 25th April,
So I may be permitted to correct that typographical mistake.
25th April. The also call for the case record of criminal appeal number 28/2023
Oh, beautiful.
from the Court of London. Additional Session Judge within bracket FTC Borpeta, as well as case record of NI case number 217/2022 from the Court of Judicial Magistrate First Class Borpeta. List according.
Regarding that correction, Lordship,
The learned counsel for the petitioner submits that a typographical error has cropped in
the cost title only.
the cause title, and he has prayed for correcting the same. The prayer is allowed. The petitioner shall you file an amended cause title.
Yes, Lordship.
Petitioners shall make necessary corrections and file an amended cause title within 3 days from the date of this order.
Yes, Lordship.
Within-
On the reopening, they are valid.
Within 7 days from the date of
Yes.
this.
I am obliged. Lordship.
Yes.
We have filed
Receive the copy.
Yes, what is,
Yes, Lordship. Who received the
she
copy?
has made her submission only.
Yeah.
You want to say something else after their objection?
Lordship, he has stated what is written in the Lordship, in the judgment, Lordship. That is there. What was Lordship query that to that regard, there is no reply, Lordship.
You know, what is your objection regarding grant of suspension of?
That from the consent position of the applicant.
No, her submission was 55, 52 A has not been followed.
From the judgment, what I have found is that the lordship, the inventory was prepared. It's not that
Before the
inventory was
magistrate.
prepared.
Show me.
Yes, lordship was
Exhibit.
prepared, main petition is the page number 54.
I have one there. No, executed of-
Main.
That was, on that last occasion I have shown what was the inventory they, what type of inventory they have prepared, Lordship.
Page number?
Page number 54.
54 of judgment. Judgment, ne? Huh? Judgment of main appeal, na? Main appeal.
Yes, para?
Para number 71. Where is it out?
Yes.
Lordship, there before that, the same submission was made regarding the PPT in the earlier paragraph, 70. Now, the largest court below is stated, but here in the instant case, as it relates from the evidence and circumstances of the case, that there is no petition for pre-trial disposal of the same contraband and inventory was prepared for taking the stock of the said article, which also accordingly stand before the larger magistrate, which is seen by the magistrate. But there is no such petition accompanying for disposal of the said contraband. Also, there is no accompanying petition is there. It's finished. But the thing is that, lordship, that the inventory was prepared and accordingly stand before the larger magistrate. And that was.
No, mere seeing the inventory is not sufficient. You have to certify the correctness of the inventory prepared. And the sample has to be collected in front of the magistrate. And that also has to be certified, whether that was done or not.
From the,
That you relied on some judgment.
Yes, and some more judgment is there regarding that lordship. Mohanlal to the Mohan-
Don't give more judgments.
One-
Give
one-
specific.
One judgment Mohanlal, from which it was enumerated lordship. Mohanlal.
Where are your earlier judgments?
Earlier judgment, I have given lordship regarding suspension of sentence and after completion of the half of the punishment lordship.
Which judgment?
আমি দিয়া করি, sir.
This 2021.
Yes. 21 to 2021.
And this
2021, 3110, that one loss.
and this
And another is 2023.
23 is paragraph.
Paragraph lordship will find here. Paragraphs, it start from 15, 17 lordship and 18. 15, 16, the Mohanlal case is mentioned. I would like to submit Mohanlal last paragraph, lordship. All details are discussed. I need not to discuss all these things or
Which paragraph?
paragraph 31. It is summed up, lordship, by after threadbare discussion in the judgment, lordship. 31.1 regarding this, lordship. What my submission was earlier occasion, lordship. To that regard, no sooner the seizure of any narcotic drugs or psychotropic and controlled substances and conveyances is effected, the same shall be forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate with an application. Section 52A subclause 2 of the Act, which shall be allowed by the magistrate as soon as may be required under section 3 of the section 52A, as discussed by us in the body of the judgment under the heading of seizure and sampling. The sampling shall be
Okay.
done under the supervision of magistrate as discussed in para number 15 to 19. 15 already here discussed in earlier latest judgment, lordship, in 2023. 15 and 16 discussed. That is why I don't want to repeat that, lordship.
Heard Miss S.K. Nargis. And I heard Miss S.K. Nargis, learned counsel for the applicant. Also heard Mr. K. Bosho, learned additional public prosecutor. So this application under section 489, 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant, Sri Kapoor Singh, praying for suspension of the sentence imposed on him by the judgment and order dated 6/8/2022 by learned Special Judge NDPS Kamrup Metro Guwahati in NDPS case number 26/2019. So by the said judgment, the applicant was convicted under section 20B2C of the NDPS Act, 1985, and was sentenced to undergo rigorous imprisonment for 10 years and also to pay a fine of rupees 1 lakh, and in default of payment of fine to undergo further
6 months.
simple imprisonment for 6 months. Stop. The applicant has impugned the aforesaid judgment by preferring the connected criminal appeal, which has been registered as criminal appeal number 277/2022.
No problem.
The gist of the relevant facts in this case is that on 27/11/2018, one Shri Vishwajit Rabha, SI of Police of GRPS lodged an FIR before the officer in charge of GRPS Guwahati, inter alia alleging that stating that on that day at about 7:30 a.m. ASI Sharwan Kumar Jha, along with the other police personnel, was conducting checking of coach number, what is the coach number? A1?
Coach number 83.
Coach number A3 of train number 12423 DN Dibrugarh NDLS Rajdhani Express, which was standing at platform number 1 of the Guwahati railway station. And during said checking, the said team recovered 5 packets of suspected ganja wrapped in black color polythene paper from 2 accused persons. Here, how many appellants are there?
Only one.
1. 2 accused persons. Including the present applicant. Stop. Thereafter, the said bag containing the packets of suspected ganja was seized, and on weighing, it was found that 30 kg ganjas what was the weight of the
22 kg.
in your
Against a FIR, yes.
22 kgs of ganjas was found. Ultimately, on where is the impugn judgment?
Judgment lordship will find in the main case
Main-
lordship at page number 28 lordship. We start from 26. Lordship will find the relevant person at 28.
What was the last line? Was found. So after receipt of the aforesaid FIR Guwahati GRPS case number 333/2018 under section 20 within bracket C of the NDPS Act, 1985 was registered and investigation was initiated. Stop. Ultimately, after completion of the investigation, charge sheet was laid against
Against the applicant,
only one,
only one.
against the present
So
applicant.
see, in this case, one accused was there. Earlier, also, one accused was there as a passenger, then lordship, charge sheet also filed against one accused person.
Against the applicant under section 20 within bracket C of the NDPS Act. Stop. The applicant faced the trial remaining in custody.
Yes,
Applicant faced the trial remaining in custody. Stop. The charge under section 20B2C of the NDPS Act, 1985 was framed against the present applicant, and when the said charge was read over and explained to him, he pleaded not guilty and claimed to be tried. To bring home the charges against the accused, during trial, the prosecution side examined as many as 6 witnesses. Stop.
Six.
The 6 witnesses.
yes, boss.
The applicant was examined under section 313 of the Code of Criminal Procedure, 1973, during which he pleaded his innocence and denied the truthfulness of the testimony of prosecution witnesses. However, prosecution witnesses, though he answered though to a question posed to him during his examination under section 313 CRPC, he answered that he would be adducing defense evidence. However, he failed to adduce any evidence in defense. Ultimately, by judgment and order, which has been impugned in the connected appeal, the applicant was convicted and sentenced in the manner already described in the foregoing paragraphs. Stop. Learned counsel for the petitioner has submitted that the petitioner has already completed more than half of the term of the sentence imposed on him. He has completed 5 years,
3 months, 7 days.
3 months, 7 days as on date. It is also submitted by learned counsel for the applicant that the health condition of the present petitioner is not good, and as per the medical, as per the documents, as per the health status report submitted by the Superintendent of Central Jail, Guwahati, the applicant is suffering from color blindness and other ophthalmological ailment, as well as he's suffering from high diabetes and blood pressure.
Yes.
Any other ailment?
Other also medical term is there.
Stop.
I could
Stop.
not.
Learned counsel for the petitioner has also submitted that in this case, the trial court has ignored the fact that the mandatory provision of section 52A was not followed by the prosecution side during investigation, as the seized contraband was not not produced before the officer in charge of GRPS police station after seizure and thereafter taken to the jurisdictional magistrate for certifying the inventory. It is also submitted by learned counsel for the applicant that no certification of the inventory of the seized contraband has been made by the magistrate as required as per section 52A of the NDPS Act has been made in this case. It is also submitted that there is also violation of the requirement of the provisions of section 57 of the NDPS Act, though learned counsel for the petitioner also fairly submitted that the requirement under section 57 is not mandatory but directed stuff. Learned counsel for the petitioner has learned counsel for the applicant has also cited following rulings of the Apex Court of India to impress upon this court that the mandate of section 52A of the NDPS Act has to be followed by the prosecution side, which was totally ignored in this case. Dash number 1, Bothilal versus Intelligence Officer, Narcotic Control Bureau, reported in 2023 SCC Online SC 498. And number 2, Union of India versus Mohanlal and another, reported in 2016 TSCC 379. Learned counsel for the petitioner has also cited a ruling of the Apex Court of India in the case of Mosa Koya KP versus State within bracket NCT of Delhi, reported in 2021 SCC Online SC 3110, wherein it was observed, wherein relying on the wherein citing the judgment of Punjab and Haryana High Court in Daler Singh versus State of Punjab, reported in 2006 SCC Online PNH 1591. It was observed that where the convict is sentenced for 10 years for having conscious possession of commercial quantity of contraband, he shall be entitled to bail if he has already undergone a total sentence of 4 years, which must include at least 15 months after conviction. Learned counsel for the petitioner has submitted that the present petitioner, wherever I mentioned petitioner, mention applicant. The present applicant has already been detained behind the bars for more than 5 years and
5 years, 3 months, 7 days.
and he has been detained since the date of,
Date of arrest, Lordship,
no, since when?
since 15,
Initial arrest,
15/12/2018.
since 15/12/2018, that is the date of his initial arrest. Consider, learned counsel for the applicant has therefore submitted that considering the rulings of the Apex Court of India cited by her, as well as considering the fact that the mandatory provisions were not followed by the prosecution side, as well as considering the health condition of the applicant may be allowed to go on bail and the bail during the pendency of the hearing of criminal appeal number 277/2022 and the suspension and the execution of sentence imposed on the present applicant may be kept in suspension during the pendency of the connected appeals. On the other hand, Mr. K. Busher, learned additional public prosecutor, has submitted that the contraband seized in this case involves commercial quantity of ganja, and therefore section 37 of the NDPS Act would be applicable even at the appellate stage while considering an application under section 389 of the Code of Criminal Procedure. He has submitted that the applicant was found in conscious possession of the seized contraband and all the mandatory provisions of NDPS Act were followed in this case. Stop. I have considered the submissions made by the counsel for both the sides and have perused the materials available on record very carefully. Since the connected appeal where the impugned judgment and order has been, where the judgment and order by which the present applicant was convicted and was sentenced has already been put to challenge in the connected criminal appeal. This court does not intend to delve deep into the evidence and scrutinize the evidence of the prosecution witnesses in depth at the stage of considering an application under section 389 of the Code of Criminal Procedure. However, this court is also considerate. This court is also conscious of the fact that the appeal of the appellant, connected appeal of the appellant, would not be heard for last 5 years, and during this period the applicant has been detained behind the bars. Though the embargo of section 37 of the NDPS Act is also applicable at the appellate stage, even at the appellate stage. However, it also appears that prima facie, it appears that there is nothing on record to show that the contraband was produced before the magistrate and inventory was prepared and it was certified in the manner as prescribed under section 52A of the NDPS Act. And therefore it appears that at least prima facie, there was a non-compliance of section 52A of the NDPS Act. Further, taking into consideration the observations made by the Apex Court of India in the case of Mosa Koya KP versus State within bracket NCT of Delhi within bracket Supra, where it was observed that no, where in last one? Taking into consideration. This court is of considered opinion that since the petitioner has been languishing behind the bar since last 5 years and his appeal is yet to be heard, and also taking into consideration the health condition of the present applicant, this court is inclined to suspend the remaining part of the sentence during the pendency of the criminal appeal number 2277/2022, and also allow the petitioner applicant to go on bail of rupees, how much? 50,000 with one surety of like amount to the satisfaction of London Special Judge Kamrup Metro, with a condition that, with following condition, that he shall surrender before the Special Judge Kamrup Metro or wherever he is directed to surrender if ultimately his appeal fails in this case. Number 2, he shall not indulge in the similar offense with which he has been convicted in this case. With above observation, this interlocutory application is hereby disposed of.
Behind the
He's behind about 5 years, more than 5 years.
that's
Because judgment was delivered on 6/8/2020.
Appeal, I have not mentioned anywhere that appeal is pending for 5 years. Appeal period, I have not stated anything. And in appeal is already listed on 11/5. No. When the appeal would be come up in a criminal appeal, let it come up for hearing after 4 weeks. Heard Ms. S. K. Nargis, learned counsel for the appellant, also heard Mr. K. Bashir, learned additional public prosecutor. This appeal is ready for hearing. Let this appeal be listed after 4 weeks for hearing.
Would the appeals, would the higher dispose?
Next item, in view of the orders passed in I number so and so, this I also stands disposed of.
Deeply obliged. So sir, I beg to item number 14, Lordship, that may be passed over for the day, Lordship.
Item number
14, Lordship.
14
Lordship.
on request of who is for the other side?
I pay for respondent number 2. I pay for fixed date.
All right, if he is ready, then I can do today. Lordship.
Scanner guess. Who prays for an adjournment? Also heard Mr. D. Gogoi. You are Mr. D. Gogoi. Heard Mr. A. Borua, who concedes to the prayer and only prays for fixing this matter on a fixed date. Prayer is allowed. Sorry, let this matter be listed on 25th April.
Obliged, Lord.
May it please be Lordship, at the very outset, a big apology. Yesterday, I could not come out from the court. Up to 4:30, I had to remain there. That's why I'm sorry for that. The inconvenience caused to my planet friend as well as the court. Well, this is the Quashing petition file against the case of 406 filed by my wife against me before a criminal court, wherein
LCR, Putul. LCR,
no LCR has come, I think.
but LCR was not required. But LCR was called for. Okay, if it is not required,
The honorable court was pleased to bring it, and my friend is saying that it is not required.
okay, let us hear.
And my lord, in this case, learned court issued the process. What was in the criminal case she has mentioned, my lord, I take your lordship to annexure 1. The complaint is the housewife, the accused is the husband. There are 2, page 11. This and 3 are the sister-in-law. The complainant of the accused number 1 is working as a area sales manager in the private firm and having rupees 80,000 only per month, besides rental income and house given to rent. Furthermore, is also having a grocery shop at his residence, where from he is earning about 50,000 per month. That the complaint begs to state that the complaint got acquainted with the accused number 1 through some relatives, after which the parents and the relatives performed the Roka community as a Roka ceremony in the month of August 2022. The complaint got married to the accused number 1, that is the Mongol Chauhan, on 25/11/22, as per the Hindu rites and rituals at JD Grand Inn, house number 230, AK Azad Road, Bahar, Gopinath Nagar, Guwahati. It is pertinent to mention here in that after the marriage, the complainant
Which
was
order
taken.
you are impugning?
I'm reading page 11, madam.
No, which order you have challenged?
Challenge the entire proceedings because 406 is not maintainable against the husband. There is a decision of the apex court, our own high court, followed by that. So, madam, what she has prayed in this, she prayed in this case, madam. I take care of the prayer portion. In the premises aforesaid, Your Honor would be graciously pleased to admit this petition and be pleased to issue a search warrant under Section 93 of the Code of Criminal Procedure for recovery of the treason articles through local police station as mentioned in the list and closed with the petition. And after hearing, the parties be pleased to convict the accused person of the charges leveled against them and pass an order of punishment, etc. Now, my learned court, after receiving this matter,
What happened? Page 25, kindly come to page 25.
Yes.
The complainant, namely Reena Rai Chauhan, is examined under oath. Upon consideration of the statement of the complainant recorded under section 200 CRPC, as well as to the contents of the complaint, I find sufficient grounds to proceed against the accused person, namely all these things 1123. Issue summons to the accused persons, namely Mangal Chauhan, Srimati Nisha Chauhan, and Poonam Chauhan, along with show cause notice as to why such search warrant shall not be issued against under section 93 CRPC, fixed on 7/7/20. We have approached before your court, my lord, on June 25, June 23, my lord, before this date, my lord. An honorable court, on taking this, hearing the matter, issued notice to them. Now, my lord, whole case is that whether 406 is applicable against the husband. There is a common belief that 406 section, the breach of trust, is applicable to everyone.
Applicable?
Applicable to everyone. Where there is a offense committed by the anybody for breach of trust. Now, what is she said that during the marriage, dowry, as a dowry, all the ornaments were given. And she has came out from the house. Husband has not given his. Now she has knocked to the court. She will not go. She has filed a case and prayed for search warrant so that police will go and find out this matter and she will get it back. Now, honorable court has, before issuing the search warrant, we are before your lordship. We are before your lordship. Now, whole contention is that whether 406 is applicable to against the husband and other persons. That is the whole contention and crux of the matter. Now, there is a very leading case in this matter.
What ground you have taken for?
Beg your pardon?
What ground you have taken in your petition?
I have taken, yes. My lord, kindly come to para 7. Para 7, page 5. Instant case that para 6.
Okay, okay.
406 will not lead to any conviction of the petitioner upon trial under the present facts and circumstances and will be an abuse of the process of law. As such, this instant complaint proceeding is liable to be set aside. Now, the petitioner
Now, why it will
that.
not lead to any conviction?
Beg your pardon?
Why it will not lead to any conviction?
Why
have you mentioned that it would not lead to any conviction of the petitioner?
Because 406 is not maintainable against the husband. Supreme Court has held that this property, even if it is a dowry, when a property has been given to the husband during marriage to the daughter or the husband as a dowry, my lord, it constitutes a specific offense under Dowry Prohibition Act, not 406. That is the dictum of the Supreme Court, my lord. In a leading judgment, I will place before your lordship. That is my contention, my lord. That's why I have mentioned, my lord, Stridhan becomes duty of the court to encourage the genuine settlement rather than proceedings of the trial, that too under section 406, which is illegal, arbitrary, and bad in law. Now, that the petitioner begs to submit that there is no prima facie case having been made out on offense under section 406, which aforesaid ought to have been filed under provision of the Dowry Prohibition Act 2005. Supreme Court has said that, yes, well, these are the properties that you have given during marriage as a dowry. You filed case under Dowry Prohibition Act, not 406. So, my lord, 406 is since not applicable. to my humble submission, my lord, the entire process is nothing but it is the time killing misuse of procedure for all them, rather to go for settlement if possible, because it is a matrimonial dispute, my lord. Now, what apex court said that, my lord, on this point? My lord, I have given copy because on that day matter heard by my Lord Justice Thakuria at length. I have matter at length it was heard by Justice Thakuria the other day. আপনি সুপ্রিম কোর্টে দিব হরমনজিৎ সিং আলওয়ালিয়া সুপ্রিম কোর্ট yes that is that sorry my lord 482 my lord exceptional circumstances justifying the exercise of the power under section 482 abuse of the process of the court criminal proceeding learns to harass the husband and in-laws due to matrimonial differences. Matrimonial dispute arising in Canada, where the FIR laws in India, no prima facie case of cheating or criminal breach of trust made out. Superintendent of police, after considering the investigation, husband and in-laws had filed late, not committed any offense, yet charge sheet has been filed against the appellant, held High Court ought to have exercised the discretion under section 482. What happened in this case, my lord? In spite of the fact that no offense is committed, but charge sheet has been filed under section 406 for not allegedly not returning the treason. I am not feeling well also. I was out of station for all these days. I came to everywhere started. That's right. I'm suffering cough. No.
It may take some time.
No, but I'll carry on. My friend is very restless. Yesterday I heard. No, I am finishing. Maybe I may. This is not a problem for me. So, my lord, your lordship got it, this matter. Then I will come to next para.
Yes.
So what said that proceedings in question, quast 406, 415, 420. In that case of charge sheet under 406, 420, 415, and it has been quashed by the apex court. Though High Court has upheld it, and Supreme Court has said that no, it is wrong committed by the High Court, Punjab and Haryana. Now, my lord, I take your lordship, the other part, other parameter, this kindly come to page 714, my lord, of the judgment. 714 under head note C. You got it, madam?
Yes.
704. 405. Now that before 406, 405 is the 6 is the penal section. Criminal breach of trust, ingredient. Taking away of dowry articles of my husband and in-laws. Section 405 IPC. Vis-a-vis special legislation contained in a Dowry Prohibition Act 1961. Section 3 and 4. Such an offense were alleged held, in fact, should have tried under the special legislation rather than general provisions contained in the IPC.
But her plea is that it is not dowry, it is her stridhan.
It is stridhan.
There is a difference between dowry and stridhan.
They say it is during dowry, it has been given at the time of marriage. What given to the wife during marriage, it becomes automatically stridhan. As Supreme Court says in this historic judgment, stridhan is not exclusively owned by the wife. It is a joint property by both wife and husband.
Where? Sure.
I'll show you. I'm coming to next one. So, my lord, Honorable Apex Court said that it should have come under the special act, since the offense is under Dowry Prohibition Act, it should have been under section 3 and 4 of the Dowry Prohibition Act instead of the IPC. So, movable property in joint possession of the husband and wife, D, paragraph D, my lord. Joint possession, movable property in joint possession of the husband and wife because at the time of when it was given, it becomes the joint property of both. Though there is a common belief that everything belongs to the wife. Law has changed, time has changed. Time has changed. Nowadays, in a maintenance case, apex court said that since wife is a highly qualified lady, let she go and earn. That is the situation. Time is changing, time to time. Law is always changing. Now, what happened? Held that husband who is alleged to have taken away articles cannot be considered to have committed theft. Or here it is breach of trust. Then, my lord, I am coming to another. What is the findings of the apex court in this very big judgment, my lord? I am coming to the last para because this comes to paragraph 30, my lord, kindly. Page 724. 724, paragraph 30. It is therefore evident that the element of wrongful intention should ordinarily exist from the inception of the contract. FIR does not satisfy that aforementioned test. This is also not absent in my case. So far as the allegation in regard to the criminal breach of trust, aforementioned test, so far as the allegation of regard to the criminal breach of trust is concerned, it relates to the dowry article. No allegations has been made that the appellants are guilty of commission of any offense punishable under the section, so only under section 3 and 4 of the Dowry Prohibition Act. If any dowry has been given, the same would attract the provisions of the special act in preference to the general statute. IPC is a general statute. Furthermore, if any article is given by way of dowry, the question of entrustment thereof on behalf of the bride would not arise. That is also very important, entrustment. So, ultimately, case was quashed. The same principle is applicable to my case, my lord. In a similar case, there have came up before our Honorable High Court, my lord. I take your one judgment, my lord, but also I was a lawyer, my lord. It is kindly peruse the Ranjit Goswami. Criminal petition number 771, 2022. Ranjit Goswami. My lord, in this case, Honorable High Court, I am reading. Moving the instant petition, Mr. S.C. Vishwas, learned counsel for the petitioner, has relied on two judgments rendered in her emergency Preet Singh Alwalia and other versus State of Punjab, other reported 2007-9 to say SCC, and criminal petition number 626/19 passed by the single bench of this court, Mr. Sanjeev Kumar Singh versus Srimati Mema Devi. Issue notice to the respondent, AD, call for the legible scanned copy of the case record, lease the matter after 4 weeks, till returnable date, further proceeding as state, matter is still pending. And that's why court wanted to know what is in the original petition. That's why your lordship was kind enough to call for the record. At least scan record is required to be perused by the court. And my lord, this case is still pending. Another case, my lord, I am referring, my lord, that is also Apex Code 2009. Or Horman we have given. My lord, another case, my lord, Pradeep Das. Now, my lord, what happened? The wife has filed a case against the for 406, my lord, in this court CGM, Borpeta. Now, that was under challenge by us, 406 is not applicable. Honorable High Court, my lord, how because we have disclosed the Honorable Court. We have filed also divorce matter, my lord. That's why, my lord, we thought that if wife has given something, we wanted to let them come to take away the goods. We have honestly submitted to the Honorable Court. Joe, Honorable Court has said that. My lord, I've heard about criminal petition, but I take the lordship. My Lord Justice Suman Sham. Criminal petition is challenged against the order dated 1/11/18 passed by the learned judicial magistrate first class Borbeta, taking cognizance of CRK such. Mr. Vishwa submit that his client is willing to return this Sridhan to the respondent and to settle the matter amicably, but the issuance of process has unnecessarily subjected the petitioner and his formally members of the undue harassment. Now, my lord, this case, accordingly, what happened? Honorable Court has directed petitioner take steps to service of notice that she did not appear. Further proceedings is consultation and such is suspended till returnable date, subject to the condition that within 2 weeks from today, petitioner shall file an inventory of all such Sridhan articles which are lying in her custody, in his custody before the learned judicial magistrate. Accordingly, we have filed a petition before the judicial magistrate. Yes, these are the furnitures who are with us. Ornaments she has taken away. Now, in the meantime, she has never come to take back those things. Judicial separation, the divorce was finally decided, and we have to pay, my lord, what is the amount is required. Court has, as per the new decision of the apex court, we have to pay about 12 lakhs rupees to her as a final settlement after divorce. Now, my lord, so all doors are open to them. When life is not happy with each other, door is open for them. If they go for divorce, I'm ready. And it is so many cases have been filed, one after another.
You have not returned back this Sridhan. It is still with you.
Has there been anything with us? All
LCR has not, LCR has come.
LCR.
Okay. Page 35.
35 minutes, next one.
Yes.
It was, this informant is one Govinda Chandra Gogoi, my lord. He lost the FIR on 15/10/2007, my lord. I'd like to inform you that on 15th and around 3 p.m., we are going to inform the residents of the same village, namely Jyoti Sangmai, Rana Sangmai, Latu Gogoi, Mohammad Ustub, where severely slapped and kicked one customer at Neptune Hotel. After some time, above mentioned 4 persons came to hotel, attacked badly the owners, Pankaj Gogoi and Pinukul Gogoi. And thereafter, you are requested to take appropriate action, so and so. This accused number 4, the other 2 appellants were not mentioned, namely Nebojit Gogoi and Nipujit Gogoi were not mentioned in the FIR. And ultimately, this injured Pinukul Gogoi expired at the hospital. And accordingly, case was registered under section 302. Now, after recording the evidence of the, because we have taken a plea of right of private defense in this case, your lordship, and the finding of the court, your lordship may kindly come to the finding, my lord. That your lordship may kindly come. The page 100, my lord, it says, my lord.
Yes.
Their court has discarded the evidence of the prosecution witnesses, your lordship. The verses that your lordship will find from 99 onwards, the page paragraph 89. Likewise, defense prosecution has not left any stone unturned to establish the accused were the actual aggressor. It is felt that to run the wheel smooth in this direction, persons like those of the eyewitnesses have shifted the place of occurrence again to the hotel Neptune from the front place of space at National Highway 37 of Neptune, thereby giving impression that all accused forcibly opened the rolling shutter to close and drag the bare hands of Pinukul and Pankaj from inside the hotel and assaulted them in the veranda, and with sharp and weapon. The versions of PW so-and-so were found to be same with their statement under section 164 CRP recorded after a week, but their versions are found totally different from the occurrence. The statement recorded by police immediately after the occurrence. The glaring contradiction along with the following grounds, version of the above and witness are discarded to be full of exaggeration and gainsay to squeeze the accused to the arena of aggression. All the above eyewitnesses, except so-and-so, are interlinked with Pinukul and Pankaj either by profession, business, or tenant. As such, they are absolutely interested witnesses. Remarkably, PW 18, the provincial court, the person with whom the initial incident had occurred stated in his statement so-and-so, having seen him assaulted the so-and-so, the manager of the National showed him the way behind the dhaba to escape. I accordingly escaped. This clear statement of the witness clearly demonstrates the claim that Pankaj Gogoi, that accused, attacked him while he was talking to so-and-so, so-and-so. Govinda Chandra Gogoi, in his version as PW1 stated, he saw so-and-so coming from towards the hotel in a gypsy, but before a second. This is irrational. Any person with sound mind attack someone with a rhyme and reason. Apparently, it manifests that none of the accused had any previous enmity with the accused Pankaj and Pinukul. Therefore, we cannot accept the version of the witnesses that accused with no reason suddenly went inside the hotel and started physically assault. Remaining independent witnesses, namely so and so, all these way, having found no material to decide the issue of aggressor, as this is the only factor to decide in this case of an undisputed stand of the occurrence, the date of pinnacle in this occurrence. Therefore, we record that version of these witnesses deserve no appreciation and evaluation at length. Report of Dr. So-and-so, examined by the victim Pankaj Gogoi, corroborates the ocular versions of the prosecutor's witness as regard the position nature of the time of injury of Pankaj Gogoi, as recording same is accepted. So then he discussed about Dr. Subrojyoti Dekha, conductor of Pinnacle Gogoi, that is caused by blunt object, and PW 23 Amril Hussain. So in this work, we do not find any illegality, impropriety in process of investigation conducted by them. Irregularity as a cross case pertaining to case was investigated, same investigation which is brought to light by defense, but irregularity is not the fatal. At the tail, there are 5 defense witnesses, which includes 2 accused persons, 2 doctors who examined the injured, accused, and court staff, namely Dodon Hazarika, who identified the signature order says. That's all. The version of defense witness is that the accused persons were not the aggressors, and the second occurrence that they accepted their first occurrence of assault or to PW1 frontal core inside the depth zone. To establish that they focused that Pankaj and Pinnacle first attacked them with iron rod, spring, only to get rid of the accused had to counterattack them with a piece of bamboo. Further, they asserted that they sustained injury in the process, in the fight, to prove their injuries they have brought the doctors who examined them. Process of the defense witness by prosecution brings to light there is no denial of the injury sustained by the accused in the second occurrence. Defense effort to culminate the accused to be aggressor of the second occurrence by way of putting suggestions needs to be retained on the grounds of rationality, prudence, and available textual records. Simply of pride of revenge is also not found sustainable on the following ground. Admittedly, accused were not the aggressors of the second occurrence. By virtue of them being members more than one number, the aggressor, namely Pankaj and Pinnacle, accused could avoid the occurrence. Injuries received by the accused do not support the plea of private. Imminent threat to their safety as minimum, they could have avoided the fighting. The aggregated situation by hiring a deposit and NIPU inside the resorting to public authority, in spite of resorting public within the soil. For the reasons we arrived at conclusion, the accused were not the aggressor of the second occurrence we are dealing with. And as Pankaj and Pinnacle initiate the second occurrence with a physical assault of Jyoti and on the highway in front of the hotel, they were the real aggressor of the so-and-so. Plea of private defense is not acceptable considering the aggressive act out of action. So my lordship will kindly see when he has come to a finding that they are not the aggressor. And the finding started at the instance of the prosecution witnesses, the deceased and his brother. And ultimately, occurrence took place. There was a fighting between two groups. We also got grievous injury. They also got grievous injury. So, question of private defense will come, my lord. Now, how the court can come to say that we were not allowed to give private defense? We should have gone for the public authority. Where is the time? That part of the finding is permissible. Otherwise, you would have given us the benefit. Under normal circumstances, I was entitled because when you are holding that they are the aggressors, you have belied the prosecution version, there's an exaggerated, whatever, then you have to go by a defense case. And then again, your lordship.
Since when you are in custody?
Custody, sir, your lordship, judgment was passed way back in 39 2023, my. More than 5 months, 6 months in that.
Anything else?
That is by the from the very judgment itself, my lord. All along they are saying that we are not the aggressors. It was a mutual fight. They are the aggressors.
No, any other submission?
Otherwise, my lord, submission by back revenge that and other two are not named in the FIR. Other two culprits who are there, only 4 persons were named in the FIR. So I am entitled for, I am entitled for acquittal, if that is case. Because it is a case where no weapons have been used. It is only blunt weapon was used.
Now, should we take it?
Now, no, nothing was used, man. Now. No, nothing. That was not a, actually the incise was not there. Only.
No, should we decide the 389 petition or take up the?
I am, my lord, your lordship, let him go on bail, my lord. All along they are in jail, my lord.
Yes, Mr. Sharma.
Lordship was rightly point out, my lord. Also
That will take
at the same time. One important thing is whether it is notice was issued or not matter in the present case.
This appeal was filed when?
Notice was issued to the, because
No, no.
informant is
This
not a major
appeal
party
is
in
of
this case.
which year?
Or 2023.
23.
Notice was issued to PP public prosecutor, not to them, because up to 10 years only they are supposed to file objection.
The quantum of sentence was 10 years or 5 years?
5 years.
5 years. Heard Mr. P. Kakoti, learned counsel for the petition applicant. How many applicants are there?
Today, with 5 miles.
5 minutes.
Applicants. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 389 within bracket 2 of the Code of Criminal Procedure, 1973, has been filed by the applicants, namely 1, 2, 3, 4, and 5. Praying for suspension of sentence which was imposed on the said applicants by the judgment and judgment dated 30/9/2023 passed by learned additional sessions judge Ibohagor in sessions case number 165 within bracket S-S bracket close /2010, whereby the present applicants were convicted under section 304 part 2/34 of the Indian Penal Code and were sentenced to undergo rigorous imprisonment for 5 years. They were also convicted under section 325 of the Indian Penal Code and were sentenced to undergo for rigorous imprisonment for 1 year and to pay a fine of rupees 5,000, and in default of payment of fine to undergo another rigorous imprisonment for another term of 3 months. The aforesaid judgment has been impugned by the present applicants by preferring a connected criminal appeal, that is criminal appeal number 465/2023. The facts relevant for consideration of the instant application is that on 15/10/2007, one Govindo Chandra Gogoi had lodged an FIR before the officer in charge of Ibohagor police station, inter alia, alleging that on that day, that is on 15/10/2007, at around 3 p.m., the informant came to know that the this Jyoti Changmai, Rana Changmai, Latu Gogoi, these are the appellants. That the applicants had assaulted one customer at Neptune Hotel and he became senseless. And after some time, the accused persons named in the FIR within bracket the present applicants came to the said hotel and assaulted the owners Pankaj Gogoi and one Shri Pinkul Gogoi with a dao. on receipt of the said FIR, Kebohagar PS case number 567/07 under section 448/326/325/34 of the Indian Penal Code was registered. 304B was added.
302 subsequently added. Subsequently.
Subsequently, during pendency of the investigation, Pinkul Gogoi succumbed to his injuries, and section 302 of the Indian Penal Code was added to the case. Stop. The on receipt of the said FIR, no, before that, added to the case, on receipt of the said FIR, Sipsagar PS case number 567/2007 was registered. Tarpisod subsequently expired. The investigation was initiated, and ultimately on completion of investigation, charge sheet was laid against the present applicants and one Jyoti Sangmai under section
Under section, my lord, 148, 149.
Under section 148/149/
325, 302 IPC.
/302 of the Indian Penal Code. Stop. All the applicants faced trial before the Court of Learned Session Judge Kebohagar. In the Sessions case, which was registered as Sessions case number 165 within bracket SS/2010. After appearance of the present applicants before the trial court on 10/1/2010, charges were framed under section 448/325/302/34 of the Indian Penal Code. And when the said charges were read over and explained to the present applicants, they pleaded their innocence and claimed to be tried. During trial, the prosecution side, next para, during trial, the prosecution side examined
24 witnesses.
as many as 24 witnesses. And stop. When it is pertinent to mention hearing that one of the accused, namely Jyoti Sangmai, had expired during the pendency of the trial, and therefore the case against him got abated. After closure of the prosecution witnesses, the present applicants were examined under section 313 CRPC, during which they pleaded their innocence and denied the truthfulness of the prosecution witnesses. They also adduced evidence in their defense. They also adduced how many witnesses?
Five.
They also adduced 5 defense witnesses in their defense. Stop. However, comma, ultimately, by the judgment which has been impugned in the connected appeal, the applicants were convicted and sentenced in the manner as already described in the foregoing paragraphs. Learned counsel for the petitioner has submitted that the maximum period for which each of the present applicant has been sentenced is only for 5 years. And it is also submitted that the applicant in the connected appeal has a fair chance of getting a verdict of acquittal. Learned counsel for the applicant has also submitted that though the trial court had not believed the testimony of most of the prosecution witnesses and has come to the conclusion that present appellants were not the aggressor in the incident which resulted into commission of the alleged offense, he declined to accept the argument of the counsel for the defense side that the applicants were exercising their right of private defense only. Learned counsel for the applicant has submitted that this finding of the learned trial court is perverse. Stop. Learned counsel for the applicant has also submitted that as the applicants have a fair chance of succeeding in the connected appeal, they should be allowed to go on bail after suspending the sentence imposed on them during the pendency of the connected appeal. Otherwise, in the event of ultimately finding them innocent in the connected appeal, they would be greatly prejudiced. Stop. On the other hand, learned
My submission is that if I like this is clear, but all of them begin the in their deposition method. And there is no chance of murder that can be.
okay. On the other hand, learned additional public prosecutor, Mr. B. Sharma, learned additional public prosecutor, submitted that there is no perversity in the judgment of the learned trial court. It is also submitted that the prosecution witnesses have implicated the present applicants and the trial court has correctly come to the finding of guilt of the present applicants under section
Taking lenient movement.
under section 304 part 2. It is also submitted that there is unlikelihood of any success in the connected appeal filed by the appellants. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record carefully, including the trial court record, which is presently available. Stop. It appears from the perusal of the impugned judgment that the trial court came to a conclusion that the present applicants were not the aggressor in the second incident which give rise to the present case. Therefore, this court is of considered opinion that the applicant has a arguable case in the connected appeal and a arguable case in the connected appeal to show that they acted in exercise of their right of private defense. Stop. It also appears that the applicants have been sentenced to a short period of 5 years only, maximum period of 5 years only. And the appeal, connected appeal is of the year 2023 only. Stop. And considering the pending number of pending appeals in this court, it is unlikelihood that their appeal would be heard very shortly. The apex court has also observed in many of its rulings that where the conviction and sentence against which the appeal has been preferred is for a short period, the general rule is to grant bail to the appellant during the pendency of the appeal unless something exceptional is shown by the other side. In this case, nothing such exceptional could be shown by the respondent side. And this court is also of the considered opinion that if ultimately in the connected appeal, the applicants are, if ultimately they are found to be innocent and their appeal is allowed, and if they are not allowed to go on bail during the pendency of this appeal, they would be greatly prejudiced. Stop. In view of above reasonings, this court is of considered opinion that the ends of justice demands that during the pendency of the connected appeal, that is criminal appeal number 465/2023, the sentence imposed on the present applicant is required to be suspended, and it is accordingly done. The applicant are also allowed to go on bail of rupees 30,000 each during the pendency of the connected criminal appeal number 465/2023 with a 30,000 each with a surety of like amount to the satisfaction of learned additional sessions judge Sipsagar with following conditions: that if required, if ultimately, no, condition below, the condition number 1, the applicants shall surrender before the Court of Learned Additional Sessions Judge Yubohagar if ultimately, if in the event their appeal fails. Number 2, the applicants shall not indulge in any such offense for which they have been convicted in the case for which they have been convicted by the judgment which is impugned in this appeal. With above observation, this interlocutory application is disposed of. And in main appeal is also in due course it will come. Heard Mr. P. Kakoti, learned counsel for the appellant. Also heard Mr. B. Sharma, learned additional public prosecutor. The trial court record has been received. This case is ready for hearing. List this appeal for hearing in due course.
My name is Kotoki, not Kakoto. Kotok.
Oh, okay, sorry, sir. None appears for the applicant on call. CD available. Whether they appeared before, whether the statement has been recorded. Statement recorded. They have cooperated. They are on interim bail.
They have so many documents of Buffalo Mill, but in the official report, it come up.
Okay, we are fixing it some other day. None appears for the applicant on call. Let this matter be listed again on 3rd April, or CD is there, short date 28/3. The case diary which is available shall be retained till next day.
May I please, Your Lordship?
You are on interim.
Lordship.
You have appeared before the IO.
Lordship.
Heard, Mr. What's your name?
R.L. Sutia. R.L. Sutia.
R.L. Sutia, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
09, 2024, dated 31/1/2024.
It appears from record that by order dated 22/12/2023, the petitioner was allowed to go on interim anticipatory bail, and it is submitted by learned counsel for the petitioner that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of the laying of the charge sheet, as well as in view of the fact that the petitioner has complied with the order of this court and has cooperated in the investigation, the interim anticipatory bail granted to the present petitioner by above named petitioner by order dated 22/12/2023 is hereby made absolute with condition number 2, 3, 4, 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of.
Right.
May I plead the lordship? The case diary was for. Now, my lords, in this case, all the other accused are on bail. Now, the allegation against me is that I along with the other co-accused, my lord, have committed murder of the brother as well as the sister-in-law of the informant at the night, my lords. Now, when they were sleeping in their bedroom itself. Now, your lordships kindly say the vernacular section here it is written that there's no eye evidence, my lords, in this case. Just on the later day, the next day, the dead body was recovered by the family members and the FIR was filed 2 days after the occurrence of that incident.
Anything else?
My lords.
Anything else?
My lords, and in the bail, this court itself has granted bail to the other accused, wherein the court has found that there's no direct evidence as regards to the prime accused, my lords. The government side itself has accused, my lords, the accused number. The accused number 4 and accused number 1, my lords. May lordship will find it in page number 18, annexure 3. The government themselves has told that has submitted that they are the main accused in this case, and they have, my lords, page number 20, lordship will find.
Which para?
Second paragraph, my lords. On the other hand, the learned additional public prosecutor, page 20. They have said that, my lords. They have said that, my lords have found.
Yes.
Yes, they have said that the present petitioners are the main accused who have been suspected to have main role in the alleged offense. And in that case also, my lords, lordship has found in paragraph 4, the second last paragraph, that there is no direct evidence of the second line. Second last paragraph, second line, my lord, the same page itself. There is no direct evidence, as there is no eyewitness also, my lords.
Yes, Mr. Das.
I have one real objection filed by the history will be written, where the implication is there for the present petitioner. May I read it? From the, according to the lordship, in the house of the petitioner, the conspiracy is placed before the day of the petitioner.
No, that IO is saying. No, don't give CD to me. Before that, you find out from the case diary that what IO is saying, whether any basis is there, whether any witness 161 statement or any material is there in the case diary, on the basis of which IO is making that submission. You flag those.
But whatever I have seen, lordship, it is there, but I have not found as such, lordship, many of the things is there, lordship. Suspicion on the ground there, some days ago, lordship, this person has conflict with one person.
Oh, no, apart from suspicion, anything else is there on.
Apart from this person,
If apart from suspicion, nothing is there, then he will also get benefit.
Everything is on suspicion, my lords. The other accused also.
Let me go through the case diary.
Well, let's say till then some sort of interim may be.
No, I will pass orders today itself.
Okay.
In the chamber, I will pass orders.
Okay.
I will go through the case diary.
Okay.
Into chamber.
May I please, your lordship? My lord, in this matter, what happened earlier, as different set of counsels were there, my lord. Subsequently, it has been handed over to us. So all along since the year 2018, my lord, there was an interim order operating, my lord. But on last occasion, my lord, when the matter listed on 23/1/2023, my lord, inadvertently, my lord, our counsel, my lord, the interim order
23/1.
on last 2023, my lord.
That is it.
18/1/2023.
18/1.
18/1/2023.
There is no IA pending.
No, my
No
lord.
inter.
No, my
Yes, on 18/1/2023. What happened?
My lord, interim order was not extended, my lord, but all along the interim order was operating, my lord.
But neither it was vacated.
No, it has not been vacated till date, my lord.
No prayer was made by, perhaps no prayer was made from your side.
My lord, I cannot say now, my lord, but on that day, whether prayer was made or inadvertently it was left out, my lord.
Now, what is your prayer now?
My lord, my prayer is now for in the extension of interim order. And otherwise, my lord, if your lordship takes up the entire matter, I am ready for it. But counsel for the respondent number 2 is there, informant, complainant, my lord.
Who is? R2 is absent.
Yes, my lord. DK Somal.
Heard, Mr. D.P. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Since the counsel for the respondent number 2 is not present, the hearing of this case could not be taken up. It is admitted for hearing.
Yes, my lord. And scan copy of the LCRs were also called for, and it has come, my lord.
Scan copy I see. When this list this case again on, when will you
Any date, my lord.
enter date? On 26 April. The interim order passed earlier. When was the interim order passed?
On 11/7/2018, my lord. All along it was continued, my lord, on all
11/7,
subsequent.
2018 shall continue till next day.
Deeply obliged, my lord.
Your Lordship, Lord, in this case, the notice of motion was issued on 28/1/2022. Thereafter, my lord, this case was listed on 24/2023. On that day, both of us made a prayer for listing the case for hearing. In fact, the notice was, it was not admitted.
So it may be admitted and fit for hearing.
Both of us made a prayer, my lord. That is 24/2023.
Heard Mr. A. Dasgupta, learned senior counsel assisted by A.S. Boddo. Also heard Mr. J.N. Sahewala, assisted by A.S. Boddo, learned counsel for the petitioner. Also heard Mr. J.N. Sahewala, learned senior counsel assisted by Miss G. Tukkar, learned counsel for respondent number 2 to 4. State is also a respondent.
Union of India.
Union of India.
None appears for respondent number 1. This case is admitted for hearing. Let this case be listed in hearing column after 4 weeks. Any interim is there?
Yes, interim.
Yes, that will continue.
Interim
That
order
is
shall
that is there.
continue till next,
Stay order is there.
next date.
Well, by this petition, we are praying for quashing the proceeding.
Who is for 2 and 3?
My lord,
Who is appearing for respondent number 2 and 3?
not, it's not available today, my lord.
H.K. Sharma. Who is for respondent number 1? What is the matter?
My lord, matter. So this is a family dispute, my lord.
But 376 is there.
Yes, sir, 376 is there, but not attracted here. So far, the my lord, allegation is concerned. And my lord, a victim also my lord, substantiate.
Now, what is the gist? Who filed FIR against you?
My lord, father of the victim, my lord. And victim is the my lord, daughter-in-law of the my lord, petitioner.
Oh, you are father-in-law.
Yes, my lord.
Okay.
And in this regard, my lord, victim my lord, swear an affidavit, my lord, page 41.
Exonerating you.
Yes, my lord.
And victim has to be heard.
My lord, by swearing this affidavit, victim Well, it stated that nothing has been happened as alleged in the FIR. It was, well, there was grass, and for personal grudge, this case has been instituted. Page 41 is the affidavit.
পুতুল লয়াৰক খবৰ ল'ব পাৰিব ফোন কৰি এম হুছেইন respondent's lawyer would be necessary. If he is not inclined to pursue the case, we will appoint legal aid counsel or amicus curiae. আপনি খবর নেবো, এটা বেলেগ দিন। We are fixing it on some other day.
Mile.
Any interim relief is granted.
Interim is there, Lordship.
Heard Mr.
K. Rahman.
A. Rahman, K. Rahman, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. Though name of Mr. M. Hussain has been shown as the counsel for the respondent number 2 and 3. However, he is not present in the court today. In view of above, the hearing of this case is adjourned for today. Let this matter be listed again on 4th April. The courtmaster shall intimate the counsel for respondent number 2 and 3 over mobile phone. My last line to cut it. আপনি
Obliged.
খবর নেন। The interim order shall continue 2 years.
Lordship, last time around the CD was being called for.
Heard Mr. H. Kolita, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, who submits that the case diary which was called for has not arrived and prays for some more time for producing the case diary along with the medical report. The prayer is allowed.
Lordship,
Let-
short date meeting, it's been long.
Let this case be listed again on 3rd of April.
Obliged.
Maybe. I am for the petitioner. The proceeding Miller 125 was there, and that was granted English Miller. I am paying the same Miller. And now they have filed another petition Miller for 127 for enhancement. And the proceeding is going on. In the meantime, Miller, the respondent here Miller filed a petition for praying for grant of some amount Miller for her medical treatment.
For?
For her medical treatment
Okay.
herself. So my prayer is that Miller, that amount was also Miller fixed by the doctor and which is produced before the court below Miller, and that is granted, same to same. So my prayer is this Miller, that if she is suffering from any illness Miller, she is from Borpata, and Borpata is a medical college Miller, and hospital, you know, should know. So let her be treated there, even assistance required, I will pay Miller. And why she is to come Miller, Guwahati Miller from Borpata?
No, this is a criminal revision petition.
Kill by Lord.
What is the defect in the order which you have impugned?
My lord. I have mentioned in the petition, kindly see page 20.
Which
Lord,
is the
accept.
impugned order?
Page 20, my lord.
Page 20.
20.
What is the error which is apparent?
Here, my lord, the respondent may reside at Borpata, and Borpata is available place and medical college, including hospital, my lord. She may be treated there or any other hospital. And why she is to be at Guwahati? If it is not the fact that that facility is not available at Guwahati, at Borpata Medical College and Hospital, the facility is available there. And she produced one certificate from the nursing home saying that that amount is required for her treatment without any authority. And before her treatment, that certificate has been issued. And that is Annexure 3, page 19. So these are not acceptable. Page 19.
No, question of accepting is not. You have to accept the order if it is the order of the court. What is the error in the order? Where the error, order
my
which you have.
My submission is simple, Miller. Let her be treated at Barbata Medical Hospital and any other place. I will at Barbata Miller.
So you are saying that as there is alternative option, this order should not have been passed.
My lord.
Yes.
Available other facility is there, my lord. If it is not that facility is not available at that place, my lord, then it is. Actually, it was.
No other ground. Only. Is this the only ground which?
No, other ground is, my lord, I am paying, my lord, on maintenance. Monthly, my lord, part 1, 4,000 plus 7,000 I am paying regularly. And another proceedings going on, my lord, 127 proceeding, my lord, for enhancement. For that, my lord, evidence, etc. will be taken now. And in between, another, my lord, enhancement or, my lord, medical cost, that, my lord, outside the, my lord, district. And when that facility is available there, my lord. It is not a fact that that facility is not there, my lord, medical hospital college, my lord. It is there available, my lord. And petitioner, my lord, has got, my lord, some family problem also, my lord, though he is serving, my lord. He has father, mother, and other members, my lord. And I am told that his salary, my lord, about 41,000 only, my lord. Mainly his family, father, mother.
This order is passed in separate proceeding or in the 125 proceeding?
The order was passed on 16/11/2023.
Separate miscase was registered for this purpose only. You prayed for enhancement of the original maintenance order. The 127 proceeding is still pending.
No.
This
Probably that is not correct, my lord. 125, 127 proceeding is not order, my lord. It is separate, my lord. It is only for medical. 120 proceeding yet not, my lord. No deposition has been taken place. So my submission will worship 127 proceeding may be completed there. In the meantime, if she needs any medical treatment, etc., let her do it in the medical college and hospital, Bogota, so that I can afford, my lord.
That can be much. If he can incur the expenses at Bogota for my medical treatment.
Okay.
I am ready. And so far, my that because proceeding, my lord, it may allow, may be allowed to continue. Because of this interim order, my lord, this proceeding is paid.
Okay, you are ready to incur the expenses at Borpeta. That we are mentioning. That you are submitting. Yes, say something.
No,
Then-
he is accepting, my lord. He will accept, that, my lord, respondent will incur his medical expenses at Bogota. That is his.
Expenses will be paid at Bogota.
Anyway, I'll pay at medical college hospital, my lord, from Bogota.
What would be the quantum?
Yeah.
Instead of 50,000.
No, what may be there, my lord?
It may again come to 40,000. You are ready?
No, I am an amount that I will not say, but what is the amount coming from the
No,
medical
unless we
college?
fix an amount today by consensus, you will again fight back in the trial court.
No, my submission, lordship, is this. What is the amount coming from medical college and hospital for the treatment of this treatment.
You are ready to
I'll pay.
incur the entire expenses.
What is the amount? I'll try to.
Okay.
If within my capacity, my lord.
No rider.
Maybe.
Heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Mr. N. Hawk, learned counsel for the respondent. This application under section 401/397 of the Code of Criminal Procedure has been filed by the petitioner impugning the order dated 16/11/2023 passed in FC within bracket criminal miscase number 571/2023, where by the Principal Judge, Family Court, Borpeta, whereby the petitioner was directed to deposit an amount of rupees 40,000 for the medical treatment of the respondent, which she would likely to incur for treatment of what ailment?
Page 19, left. Septoplasty.
Treatment of septoplasty. What is septoplasty?
That is medical treatment.
Septoplasty at Guwahati. Now, whether treatment is available at Borpeta?
My lord, my instruction is that facility is available.
If it is available, you have to incur. If it is not available, then because we don't know, how can we pass orders unless without verifying?
Now, my instruction, I have also told the client that the facility is available at Borpeta, that is a medical college and hospital, so that facility is available. Actually, there is similar nasal septum with sinuses. Mainly a sinus problem, or in a common language.
Septoplasty at Guwahati. Stop. Learned counsel for the petitioner has submitted that the petitioner is aggrieved only to the extent that as the treatment for septoplasty is also available in Borpeta, which has a medical college, where a medical college has also been established. The trial court should not have granted the expenses for treatment of the same ailment at Guwahati. On this, learned counsel for the petitioner has also submitted that he has instructions from the petitioner that the petitioner is ready to incur all expenses for medical treatment of the respondent if the said treatment is taken at Borpeta, as according to learned counsel for the petitioner, the treatment of septoplasty is available at Borpeta Medical College Hospital. Interfere where, if I'm wrong in stating the facts. It is available in, is that your submission?
Yes.
Stop. Co- Considering on this, the learned counsel for the respondent has submitted that considering this offer by the petitioner to bear all expenses at Borpeta, this revision petition may be disposed of with a consensus between the parties and with a direction that can be disposed of as, no, this revision petition can be disposed of as the respondent would not contest the case if the petitioner is ready to bear the expenses of the respondent for her treatment at Borpeta Medical College Hospital. Considering the submissions made by learned counsel for the petition, counsel for the both the parties, this revision petition is disposed of with the necessary modification in the impugned order to the extent that the petitioner shall be, that the petitioner Safiqul Islam shall bear all the expenses to be incurred for the treatment of the respondent Mamuni Khatun for her ailment of septo, what is the septoplasty at Borpeta Medical College Hospital, Borpeta. Stop. In the event, stop, in the event said treatment is not available in the Borpeta Medical College Hospital, the petitioner shall bear the expenses for the said treatment elsewhere, including Guwahati. With above observation, this criminal revision petition is disposed. I'll make some corrections. The interim order dated date is
28/11, my lord.
interim order dated 28/11/2023 is hereby vacated.
Must.
Sorry, may I please approach? We are challenging the proceeding well.
Whether scan copy has arrived? Yes. No, we have to wait for scan copies and whether respondent number 2.
Yes, my lord. Respondent number 2 entered appearance and filed their affidavit, my lord.
What is the matter? Today we don't have time.
Lord. Well, matter relates to out of love affairs, one agreement was executed in between parties and that relevant time.
This is quashing petition.
Yes, my lord.
Quashing of
Proceeding, my lord. Two petitioner before your lordship. Petition number 1 is my lord, son, and petition number 2 is my lord, father. Father executed the deed agreement, marriage agreement. At that time, petition number 1 was a minor. At that relevant time, petitioner was 16 years old and respondent number 2 was 20 years old.
35, 37 is regards.
Yes, Mr.
Sorry,
Ram.
regarding item number 18, one prayer
If
is
it
there.
relates to date,
Regarding 18, maybe we are praying that interim may be considered on the next.
interim may be considered on the last day.
Obliged.
In item 20.
Yes, yes, Miss.
Yes. My lord, 37 is a Jima regarding car and 2 cars has already been died. So it is if possible on 28, my lord, both these items 37 and 45.
Dates, they will.
My lord, of the
Any prayer regarding dates?
Not my lord, not regarding date, my lord. My lord, in item number 38, we filed an AB. In that AB, my lord, there is an interim order, but today this IA has come. This has been filed by the informant for cancellation of the bail, my lord. So, my lord, since the matter has not been taken up in the AB, perhaps that interim order will be extended.
Okay. AB interim order shall continue
My lord.
till we consider the cancellation prayer.
Yes, my lord. 38, AB to support.
My lord, item number 31, LCR is available, my lord, and many times this case matter is listed for orders, my lord. This matter may be listed for hearing, my lord. LCR is available, my lord, for the,
38 fixed for hearing.
and my lord, that may be fixed for hearing after Bihu or May, in the month of May.
No, no. Which year the matter is?
My lord,
This is an appeal.
yes, my lord.
This is an
Criminal appeal with interim, interlocutory bail application, jail bail, my lord.
Appeal will be listed in its due course. And the bail application we may consider. So after Bihu, we will be listing the interlocutory application.
I think 20 is only for admission. Can it be admitted? I think. Yeah.
20 become. Okay.
And one stay is required because a lot of trial court fixed for.
No, then we will take. If it is only admission, if it is stay, then we will fix it tomorrow, day after tomorrow. 27.
My lord, in item number 48, a date may be given on 1st April.
I have already mentioned.